It is 15:15 and time to start. Mr. Masters, do you know Mr. Rose whereabouts? And do you need him for the start?
I'm happy to start.
Be sure.
He was great, but he was behind.
So he's in the building somewhere. Okay.
I think I'm afraid he wasn't quite sure the timing. I took the view it was 10 past.
15:15. It was always 15:15. Okay.
Well,
Well, that better. A couple of points arose from my point of view in connection with documents during the evidence in chief of Mr. Dudley. If I've overlooked them in what I've already got, please tell me. But I think the things that I would like to see, the first is the review consultation document on the national landscape, the Surrey Hills National Landscape. I'm pretty sure I've got the management plan, but I don't think I've got the later documents. And then there was also discussion we had about thatched house and the development there. Now, what I have got, I've got the report, and I've got location and site plans as appendices to Mr. Rowe's proof. I think I'd like to see the actual decision notice in addition to the report. And I'd also like to see, there are 3 buildings which I understand to all be the same. I'd like to see elevations of one building as approved.
Yes, yeah, the brewery.
That may be something that the council can provide more readily. Okay. Right. It was agreed you're going first, isn't it? So when you're ready.
So good afternoon, Mr. Dudley.
Good afternoon, Mr. Cottle.
Just to run through some of the documents I'm going to be referring to. I've got a local landscape character assessment for Surrey that deals with Waverley. I was going to refer to some of the relevant planning histories, and that's in CW16 that we've already looked at. Mr. Ward's
document.
That's right. CW16.
Right. Okay.
Then I was also going to look at the local plan policy AHN4. And then I was going to be looking at Mr. Powell's appraisal in the statement of case on behalf of Mr. Doherty and Matthew Doherty and Mark Doherty. I don't know who was the author of that. And then there's the plan that was referred to this morning by my learned friend Robert Petro with the landscaping for Appeal B. And I was also going to be looking at some of the decisions in the CW15, which is one officer's report that you've had this morning. And I think they're also going to be set out in a statement of common ground at some point. But those are the documents that I'm going to be referring to this afternoon. Where I'd like to begin really is just to acknowledge that there have been 3 inspectors' decisions concerning this site. We learnt from a local councillor that there was one in the 1990s for the Stovolds Hill one originally. So there's been 4 Secretary of State's decisions as I understand it. But when you were originally instructed and you did your site visit on the 3rd of October, were those decision letters before you?
I was certainly aware of the decision of Inspector Gilbert, and I was aware of the decisions in Lydia Park to the south. I'm trying to think. I don't think at the time I was aware of any other decisions on the northern side of the access track that relate to the sites in question.
Mr. Scott, I wasn't sure about the scope of your question. You said, I think 3, and then I think you said 4 decisions on this site. What do you mean, this site?
Thank you for asking me to clarify that. Regarding the Lydia Park, Stovolds Hill caravan sites in the plural. That's right. Yes.
Oh,
That's
right.
right, yes,
Sorry,
yeah.
I interpret it as the appeal sites.
No.
Oh,
Three inspectors' decisions regarding Lydia Park. And had you read them?
I Yes, I think at the time I went to site, I'd read certainly the two of them. There was the first decision of Inspector Murray, and then I believe there was a second decision which was to the west from recollection. And so I'd certainly read two of the three.
And your view was that they were misguided because they weren't informed by a person such as yourself, so as to get the relationship right between the site and the AGLV and the then AONB. So they're all of them misguided.
What I was referring to in that comment in my chief was Inspector Gilbert's decision, which is to the north of the access track. However, I think in any scheme, my opinion is that in any scheme that you have a nearby nationally important landscape, a landscape professional should be appointed.
But none of them saw the relationship as material with the national.
I wouldn't know without going to those decisions because it was, as we know, quite a few months ago when I read them.
Now, there's also the subsequent decisions, and it may be helpful just to look at CW16 if we may, at this juncture.
Do you mean 16 or 16A? Just because they
Well,
are.
I was looking at 16 because I had it open, but it's the same plan at the beginning of the.
16A is easy.
All right, 16A, fine.
Yep, got it.
And the land to the south rises up towards Stovolds Hill, doesn't it?
No, I've stood on site D and been looking over Lydia Park because the land's been made up. So the baseline levels don't really apply anymore because of the amount of material that's been brought onto the site.
So there's no slope as you turn out of Lydia Park and go right towards the aerodrome.
I don't know. I haven't driven that way. So I've only turned left out of Lydia Park.
Because according to your evidence, as I understand it, all of the pitches and permissions that are referred to there on the west, it's 0176, which we know is an inspector's decision, and on the right it's 0551. None of those should have been permitted according to your evidence, because by definition they were in the area of great landscape value.
Not necessarily, because the accurate baseline position we're dealing with is Lydia Park being separated from the national landscape by a wooded stream corridor, which includes parts of the appeal sites and acts as a feature to buffer it. I'm not sure of the exact detail, but certainly there is a policy obligation under para 189 for the for schemes to be sensitively located and designed. If I had considered it, I would have probably advocated against extending Lydia Park to the north because of the reduction in the proximity to the national landscape and because of the visibility from Hascombe Hill. But I wasn't involved in those cases, so and neither was any other chartered landscape architect to my knowledge.
And your case is that there is visibility from Hascombe Hill to those permitted pitches?
Yes. With the appeal sites in the foreground.
Well, there we disagree.
Do you disagree that they are between Lydia Park and the national landscape?
No, I'm saying visible from Hascombe Hill.
Oh, okay.
Now, in relation to those permissions, you made the point that the vegetation and the trees regarding the ditch, as I call it, in front of appeal site A and appeal site B that we've seen photographs, made a difference to the context of some of those permissions because there were trees there beforehand.
Sorry, where did I say that?
Well, if we look at figure 1 point, I think it's your first figure actually, figure 1 in your proof at page 6. This is the proof of Mr. Dudley's first proof,
The site
Wait.
one there.
appeal B.
B.
So we see a line of trees there.
Because I don't have a pool B. Are the photographs in appeal A exactly the same? Yes, yeah, questions with your terms. Well, it was a clarification because I just want to make certain I'm looking at the right photo.
The question
We're at
is
appeal
this.
B. We're on appeal B proof.
The question is, those trees, in your view, made a difference to
Yes.
the context of the previous planning permissions.
That's correct.
So landscape harm can be mitigated by the presence of trees,
Not necessarily.
but they did in those cases.
What they did is they removed a degree of visibility, but that's only an element of landscape character harm.
Which is it, Mr. Dudley?
So
Either that landscape harm can't be mitigated or landscape harm can be mitigated. Which is it?
it's not that clear. Landscape harm arises from harm to the fabric of the landscape,
But in
which
those,
can include visibility. It can also include the combination of elements, perceptual characteristics within landscape. This is precisely why we divide our assessments into landscape and visual, because we consider the effects on the fabric of the landscape, and then we consider separately the effects on views. And so, yes, the trees, they did perform a positive role in the sense that they helped to separate Lydia Park. So to an extent, yes, they perform that role,
So
but not in its
vegetation-
entirety.
vegetation can make a difference.
Vegetation can make a difference, I'll agree that.
It can mitigate the effects on landscape harm.
It can mitigate to an extent the
And the
effects on
blanket
landscape.
statement by Elizabeth Pleasance wasn't meant to be a statutory code. It wasn't meant to be a tablet of stone. It was sent into context of that site.
It was underlying the point that I just made, and which I made in chief, which is that you can't make something better in the landscape by just hiding it.
But the effect on the landscape, and particularly the effect on the wider landscape, will be influenced by, for example, a row of trees.
Yes.
Thank you. Now, I'm looking at figure 1 still under paragraph 115, and I'm wondering why you took the 2018 photograph, why you didn't take a photograph before my client bought the land in July 2022.
As I said in chief, it was the clearest imagery that was available.
But if you were going to be analysing landscape impact, wouldn't it be fair to be looking at it as to when he bought the land?
I wasn't aware when your client bought the land, so I simply chose the imagery that most clearly showed the context of the site prior to the intentional and authorised development.
Well, it could affect the degree of loss if the landscape had changed between figure 1 and what it was like in 2022, 4 years later. If the trees had gone.
If the change was intentional and unauthorised, then that would be immaterial.
So that depends on the circumstances of the previous owner.
It doesn't, it's irrespective of ownership, because what I'm not seeking to do here is to judge any particular occupant of site for their activities. What I'm seeking to do is establish what is the accurate, legitimate baseline condition for the site.
So if you bought a piece of land off Mr. Lintott, and before Mr. Lintott had sold it to you, he took down a number of trees, and then a couple of, or maybe 4 years later, you decide to put in a planning application, are you going to be judged by how the land is when you acquired it, or are you going to be judged by how the land was before Mr. Lintott took the trees down?
That depends on the context in which Mr. Lintott took the trees down. If Mr. Lintott breached the Forestry Act in taking those trees down, then that would be a material consideration.
So it would depend on whether there was like some sort of preservation order on the trees.
No, Forestry Act 1967 prevents the felling of more than 5 cubic metres in any single calendar quarter.
And that wouldn't be exceeded by the front entrance to my client's site on Appeal B.
But I think it would if it was all felled.
Well, we'll come back to that point maybe later on in your evidence. Now, if we look at the question of encroachment into the field, it's fair to say that encroachment will always happen by any grant of residential use outside of a settlement boundary.
That's absolutely correct, and that's why it's so important to consider the context.
So per se, an alteration to residential use isn't necessarily harmful.
It's normally harmful to some degree, and the degree matters on the what's being proposed and the context in which it's being proposed.
Well, then we get to the point, really, as to where traveller sites are going to go. And if you accept that traveller sites can go outside of settlement boundaries, there will be some harm that will be caused by the loss of a field that's changed into residential use, won't there?
That's right.
It will necessarily be accompanied by some.
Or if anything's created, then there's often some degree of harm through loss of characteristic. And as I said, this is why the context is important. And an open field that forms the only remaining 300 metres between Lydia Park and a national landscape, in my view, isn't the appropriate place to site it.
But the point is that if loss of a field necessarily might involve harm to that field, that element of detraction doesn't necessarily trigger conflict with policy, does it?
Not necessarily.
So-
It depends on, for example, in this case, the field performs a strategic role wider than its own intrinsic value. It performs a strategic role as well.
Well,
And also it's what the field, if it was an intensive arable field that was managed for cereal crops, for example, then that would be a different context to the field in question, which is a naturalistic scrubby field, and again with the tree belts on its southern side.
Well, I disagree with you about it performing a strategic role, but come back to my question. In relation to the introduction of caravans, it's true to say that the AGLV isn't a nationally designated designation, is it?
No, it's local.
And in that sense, it's countryside, isn't it?
How do you mean?
Well, it's ordinary countryside.
No, it's an area of great landscape value. Ordinary countryside would be an undesignated landscape.
Well, could we just look at the local plan, if we may? Part 1, local plan part 1.
What's the core document reference for that,
Fair-
please, Mr. Consul?
CDA 6.6.
Thank you.
And if we could turn to chapter 13, it's landscape character. My paragraph 1328, and it's got a heading, the Surrey Hills area of outstanding natural beauty and great landscape value.
Yes.
And and in paragraph 1331, it refers to the designated parts of Surrey. And it says the AGLV is a local landscape designation that complements the A and B. It affects 6 of the Surrey districts. For much of the area in Waverley, the A and B and the AGLV designations are contiguous. However, there are significant areas around Farnham and Godalming and in the southeast borough where the LGV designation extends beyond the AONB and therefore under the MPPF does not have the same status of protection. And then it refers to the review, and paragraph 33, the assessment recommended an urgent review of the AONB boundaries. And then 2013, Natural England agreed there be an assessment recommending different areas for inclusion in the AONB. And we heard from the councillor this morning that that's been superseded by a more recent review. And then it says, until the AONB review is completed, the AGLV will be retained in the local plan. And then further down paragraph 1335, it says, however, as a local designation, the AGLV holds less weight than the AONB in policy terms. Once the AONB review is completed, any remaining parts of the AGLV not included in the AONB will have less status. And we know that the review is going out to consultation. The inspector was asking for some documentation in relation to it. But you agree that the appeal site is on land that has less status because it's not earmarked for extension of the national landscape.
Yes, that's right. In the sense that, yeah, it's not in the extension to the national landscape, and it does not benefit from the same level of policy protection because it doesn't benefit from paragraph 189, simply 187.
So rather than looking at it definitionally, why don't we do our own assessment of the attributes of the local area to see what effects, or what notable effects the introduction of these caravans might have? Why don't we just look at the local area and see what we've got? And would you include within the local area the brewery that Mr. Rowe refers to?
Yeah, I mean, that's quite entertaining because the advocate had advanced no analysis whatsoever in terms of the published character or anything.
Would you include within?
But yes, you would include in an analysis of the context of the site. You'd include all elements, which includes the presumably that those are the light industrial units, are they? The brewery.
Would you include the solar farm that I referred to? That's just north of Billinghurst Farm, between Dunsfold and Loxley Road.
Not in a context of this specific site.
Well, it's quite close, isn't it?
It's not perceptible. I mean, when you're stood on the site, you're not aware of the presence of a solar farm.
Would you include the fracking site just to the left as you go down Dunsfold Road and junction Pratt's Corner?
I'm unaware of the planning status of the fracking site.
Isn't that close enough to be looking at the area, 2 kilometres sort of?
What's the status
radius
of the fracking site?
It's granted permission.
Then, well, if it's something that's permitted, would be but when I was on site, when I was walking the area, it's not something that I was aware of.
What about the 1,800 or more houses that might be permitted on the aerodrome site? The development's going ahead. Question mark about how many houses are there? Would that be within the local area?
Once it's advanced, it would form part of the wider landscape character and some of the context from elevated views. But again, I mean, that's not in the council's 5-year housing supply.
I also,
and so it's unclear exactly, how that's going to come forward. But nevertheless, that's coming forward in a positively planned manner. And so one would expect that its landscape effects to be contained, unlike the intentional and authorised development we're dealing with in this appeal.
Well, you're not going to contain 1,800 houses from a view from Ascombe Hill. But the point really is, would the assessment of the site within the local area include these features within a 2 kilometre radius?
It would, alongside all of the other, positive landscape attributes.
Would it include the sewage works that I see on the map?
Yes, it would include all of the elements. This is the whole point. Landscape character assessment is the landscape as a whole. It's all the human and natural elements that give rise to the character.
Would you say it's a rural area that's capable of receiving new housing development?
As in, when you say rural area, what do you?
Well,
What sort of area are you referring to,
I'm
the
saying that
district
the
or
appeal
the?
site is within an area an area of landscape that's capable of receiving new housing, it's capable of receiving a brewery development, it's capable of receiving fracking sites, capable of receiving a solar panel farm.
I
Mr.
understand
Cottle, I
that.
just want to clarify something about your line of questioning. When you're asking these questions about the area to, are you making the assumption that the area that you're concerned about is the AGLV?
I'm saying that the effect of the site on the area should be judged by an appraisal of what the local area comprises.
But you started off on the AGLV, so are you going beyond it now?
Well, it's not just a definitional.
I just want to be
matter.
clear about the basis of your question.
No, I am dealing with the question of the AGLV, yes.
Well, you asked about Dunsfold, and I'm not sure that the AGLV covers Dunsfold.
Well, my question to Mr. Dudley is, when judging the effect of the appeal site on the area, shouldn't you be looking at what the area actually contains?
So you're going beyond the AGLV.
I wasn't aware that I was.
Well, according to the map that's been put in, showing me the extent of the AGLV, you are.
Right,
So I just want to be clear about the basis of the question.
thank you. I'll come back to that. Would you include the Dunsfold Aerodrome development as within the area of the appeal site?
Within the,
Is it within a 2-kilometre area of the appeal site?
yes, it is.
Thank you.
But
What we know, can we also turn, when we're looking at the local plan policy, can we also turn to page to AHN4, which is in the local plan. Sorry, I lost my page. Chapter 9, under paragraph 945. What AHN4 requires you to do is to look at the area, doesn't it? 1, 2, 3, 4, fourth bullet point down. Fifth bullet point down, the site does not have an unacceptable impact on the physical and visual character of the area. So you need to grasp what the area comprises in order to judge whether or not it has a physical impact that's unacceptable or not.
yes, you consider the character of the area.
Thank you.
Absolutely.
Right.
And so in this particular case, what I've done is I've looked at the character of the site, and I've looked at the three key elements in the setting of the site. One is Lydia Park, 2 is the wider field in which the site's located, and the third one is the rising land to the north that falls within the national landscape.
Because I was surprised not to read about AHN4 in your proof. You didn't think that was relevant.
I didn't include it, no.
But it is the most important point, most important policy, isn't it?
I'd say it sits alongside policy RE3, which is the landscape.
It governs the type
Specific.
of development that's been applied for, doesn't it?
Yes, it does. That's correct.
And your proof isn't geared to addressing it.
It is. My evidence directly addresses the level of impact. In fact, I'm the only witness that's looked at the level of landscape and visual impact of these proposals, and therefore being able to draw a credible and transparent conclusion as to whether it's acceptable or not on those grounds.
We'll just agree to disagree over that, Mr. Dudley, because
Let's.
your proof doesn't refer to AHN4. It's not geared to addressing the test that's required. But coming back to the position of caravans, we talked about the Elizabeth Pleasance decision, and we were also talking about a decision letter that Mr. Woods referred to in his proof, which was a decision of Mr. Thomas Shields at Goring, Oxfordshire. You're familiar with that decision? It's in his
Yes.
proof at Appendix 4, I have it, page 30, and at paragraph 37, sir.
Sorry, Stephen, could you repeat the paragraph number? I couldn't catch it.
37. It's the decision of Mr. Shields, Inspector Shields at Goring, Oxfordshire, which you referred the witness to this morning. That's right.
What's the core document reference, please?
I don't have that.
It's Mr. Wood's appendices, so it's going to be, I think, 7.
7. Ah, I see. I've got it. Thank you.
And whereas I was putting it to you that Inspector Pleasant's decision was context bound to the particular circumstances, and she wasn't laying down a tablet of stone, I would suggest that this inspector is actually advancing a more general principle that living in caravans, including in rural areas, is a fundamentally intrinsic part of their culture and lifestyle. That is a general proposition.
Sorry, I'm just finding the relevant paragraph. What's the paragraph number again? Sorry,
37.
37. I see. Yes, got it. Yeah.
And so it's not inherently unexpected to see caravans in the rural countryside in an area such as this.
I disagree. I'd say that it would be unlikely for developments in this specific location to be permitted because of the national landscape nearby. Countryside in general, yes, but in the setting of a national landscape and within an area of great landscape value, less so.
Well, that comes back to one of my earlier questions, which from your evidence, I understood that you disagreed with all the permissions that have been previously granted at Lydia Park on that basis.
On the, my view was that these designations should have been given greater consideration.
And when we turn to your proof at paragraph 338, if we can, please. It's fair to say that your appraisal hasn't included the fact that the local area has been capable of receiving housing, brewery, and the fracking site and the solar panel farm. Your appraisal has left those matters out of account.
No, my appraisal has taken account of the elements at Thatched House Farm, which are nearby to the site. But no, I haven't considered the fracking site or solar farm because they're further afield. And as I explained to the inspector earlier, what I'm looking at is the perceptible context of the site. But it's my role as the assessor to determine what I consider to be the relevant landscape receptors of this scheme and to make judgments against those receptors. And that's entirely the spirit of paragraph 2.24 of the guidance that I took the inspector to earlier. The inspector can disagree with my findings and can find otherwise in his decision, but what he has before him is the evidence of a chartered landscape architect that follows the guidance.
Talking about the receptors, I expected to see some sort of diagram with arrows showing me where photographs were taken from. Still haven't received that. Is there?
They're on here.
Those are the photo.
Those are the photograph locations.
Right, I see. And those are the ones that you took on the 3rd of October.
Yes.
And when we look at,
I took a lot more photos, but those are the ones that I included.
well,
in my
these
evidence.
presumably were the worst ones, or the ones that you chose to use.
I always use worst case scenario. That's standard practice for visual assessment.
And if we turn to the view, please, at figure 8. Is this the high point of the case against the appellants?
I don't think that's a relevant question because what I've done is produced an entire landscape and visual impact assessment. This is simply the photo that illustrates the experience of one of the selected visual receptors.
Well, it's a view from within the national landscape, isn't it?
Yes.
It's the closest view from within the national landscape, isn't it?
That depends whether you consider Dunsfold Road to be in the national landscape.
Well, presumably the
But it
national
is.
landscape isn't enhanced by a piece of tarmacadam, it's the other side of the hedge.
I don't know where the boundary sits. However, it's the closest, let's call it the closest public footpath view within the national landscape.
Let me just be clear which of these circles on this plan it is.
It's the circle that slightly overlaps Paynes Hill Farm Stables.
Yeah, yeah, there's two close together there, but it's the northern of those two.
It's the northern of the two, yeah,
Yeah,
that's right.
thanks.
The southern of the two is figure 9.
Because you could agree with me that it would be open to the inspector to decide that these views, obtainable as they are, aren't unacceptable.
Absolutely. This is the entire point of paragraph 2.24 is clarity and transparency in judgment. So the inspector can read my evidence, he can follow my judgments and the reasons why I've arrived at those judgments, and then he can make his decision based upon that. So yeah, the inspector's within his right to dismiss my evidence. And so he has my assessment before him.
And have you just been back there before the inquiry to check this view? Because it was taken last October, things might have changed.
I haven't been back there, but the winter views were taken from there and they confirm the views. Well, it's actually more visible from when the winter view was taken.
And
is it still a matter of dispute whether these elements are visible from the national landscape?
Certainly struggle from our point of view to see the caravans.
Okay. I'm just curious because you're
We're not
questioning me
sure.
on the visibility within on a view of them
That's
from the
that's
national
the one
landscape.
that I can see that you're telling me is the only caravans you can see are the appeal sites. And I'm trusting your evidence. It's the only, but
Yeah.
I'm not unable to verify that.
Sorry?
I'm unable to verify that.
Okay.
Because
If you'd appointed a landscape professional and got them to undertake their assessment, or if you're witnesses had considered
clearly-
abuse in the proper
clearly-
way, you'd have your own evidence.
Clearly, the other views, when you're looking at the appeal site, going up Hascombe Hill, for example, you will see the aerodrome and you will see the higher parts of Stovolds Hill.
Yes.
That's as much as I can agree. I don't have
Okay.
any knowledge of anybody seeing the appeal site from
Well,
those
that-
positions.
Okay.
And we've got the photographs that were taken by somebody else. Who was it? Mr.
Mr. Bennett.
Mr. Bennett. Because I was surprised that you included that evidence in your proof. If you've got the third edition of the GLVIA handy, please. What it says is that it's important to include technical information about the photography used of paragraph 6.25. And what the professional standards are saying is that it's important to include technical information about the photography used to record the baseline, including camera details, date, time photography and weather conditions, etc. And I was just slightly surprised that you'd borrowed somebody else's photograph and relied on it in your proof without going there and doing it yourself. Why didn't you go up there and take a photograph of it yourself when you were there on the 3rd of October?
I did.
So why haven't we got your photograph?
You do. Oh, which one are you talking about?
The
Sorry.
one that's in your supplementary proof.
Yeah, the view from 279.
Well, I thought we just agreed that there was somebody else who took that photograph.
The winter view. Somebody else took the winter view. The photo in figure 8 was taken by me using a digital
right.
SLR camera on the exact date, and I can give you the weather conditions.
Fine. But the photograph
The
that
photograph
somebody
in my
else took,
supplementary proof was taken by Mr. Bennett.
and you put it in your proof without those details that I would have expected to see. You can't verify it. You don't know what camera he was using or what lens he was using.
I don't know what camera he was using. No, that's right.
Why didn't you go up Hascombe Hill yourself on 3rd of October and take that photograph? Or did you and you couldn't see it, so you didn't?
Sorry, bear with me while I check a detail. The view from Hascombe Hill, which is my figure 7, was taken by me on the 3rd of October.
Fine.
It was a mild autumn, the vegetation was still in leaf.
And the appeal site
Subsequently
on
to
that,
that, my supplemental proof includes an image that was taken by Mr. Bennett on the 28th of February 2025 at 11:48 in the morning. You can see the weather conditions from the photo. The only information that's missing is the camera that he used, but I don't see that as material to the there was no zoom applied. I know that. So that was just a natural picture, single frame, taken by Mr. Bennett.
because you weren't there in the winter.
Because I wasn't there at that time, no. That's right.
And if we come back to your photograph 7,
Yes. Actually, no, sorry, it's not figure, it's
figure 7.
yep, that's right.
This,
So Mr. Bennett took views slightly to the west.
this isn't actually on the hill, is it? It's just sort of at the beginning of the hill.
No, figure 7 is taken from the hill.
Because I was looking at the diagram of the plan, and I thought the summit of Hascombe Hill was some way up.
Yes,
along
the
the
summit
path.
is.
So
When you say
That's
on the
right.
hill, are you referring to just the summit then? Because I
Well,
was referring to
so-
the entire hill. It's
it's as you go up, it's not.
it's about,
not
I think
where the
the
views are
photo was taken
spectacular.
at roughly the 125-meter contour, somewhere in that region.
And where we disagree is over the ability to see the appeal site as opposed to the other caravans that are permitted behind it on the higher ground.
Yes. But I know I've stood in that
And-
location and looked towards the site and I could identify the appeal sites.
You've got the point that the inspector put to Councillor Sullivan this morning. Really, when you looking at the Lydia Park development, would the caravans on the appeal site make any difference?
Yes, because they're in the foreground.
It's not.
So I stood there. I don't think any of your witnesses have stood there, taken the photo, presented it in evidence, or
Look-
undertaken an adequate visual analysis.
That
You have
is-
no evidence to challenge my evidence with. It's simply questioning my
Well,
findings. Well, the
the-
inspector has my judgments.
the-
He has my image, and we're going to take the inspector to that location
Well-
so he can see with his own eyes.
That's right. And he'll be able to decide for himself.
Yeah, indeed. That's it, which is
So-
his role as a decision
That's
maker.
right. So
And my role is to assist him.
that's right. But the point is that when you're standing there, what your eye is drawn to is the larger developments behind the appeal site.
Your eye is drawn to Lydia Park in general, and the appeal sites are in the foreground of Lydia Park. So the effect of granting these schemes would be to increase the overall mass of Lydia Park within that view and to bring it closer to the receptor.
So now we've got to this point, can we agree that whether or not planting would succeed or fail is critical to your analysis? Because your analysis is on the basis of what is there now, whereas the inspector is asked to judge the development by what it would look like as conditioned. And your premise is that the landscaping will fail. And our premise is that the landscaping will succeed.
No,
And
there's 3
if we are
points.
right and you're wrong, would it make a difference?
No, there's 3 points that I'm making, and that's only one of them. So the first point is that these are elevated views, so you're looking down into the site. The second point is that in any case, it would introduce artificial enclosures within this landscape. And the third point is what I observed on site, which is the damage to the soil, that it's being compacted, contaminated and waterlogged. And in my professional experience, attempting to establish 3-meter tall trees within a soil that's been damaged to that extent would be near impossible.
Well, we disagree with you about that, and Mr. Woods will come back on that, I'm sure, because of course, you know that you can have challenging landscapes where planting can succeed with proper specification, proper aftercare, proper irrigation, proper implementation and maintenance, that landscaping can succeed even in the most challenging landscapes.
Not the landscaping that's proposed as part of these schemes, not in contaminated soils as a rule, and you don't actually have a credible witness to speak on the establishment of vegetation in any case, to my knowledge.
The fact of the matter is that if the inspector accepts your analysis, it is based on the landscaping failing.
That's one of the 3 points that I mentioned.
Yeah. And if the landscaping succeeded, it would make a difference, wouldn't it, in terms of its visual impact?
It would make some difference were it to succeed.
Thank you. And as regards your second point, which is the effect of the hedging and the new trees, if we go back to your figure 1, if we may, in your proof for Appeal B. Sorry, it's figure 3. Is it?
Figure 3 is the one with the
Figure
red
1 or
line.
figure 3, they're both
Yeah.
June, they're both the same one. June 2018, sir. Do you have it? And if there were trees reintroduced at the southern boundary of the appeal sites, so that you have those trees on the border of the access track,
Yes.
then that wouldn't be out of place or incongruous.
No, that's right.
And if you had trees to the northern boundary of the appeal sites, along the bottom of the pitches, sorry, it's the far end of the site, look towards nearer Dunsfold Road. Again, small fields, an area of planting that goes across from the existing vegetation to the side of Appeal A, across the back of the appeal sites and back down to the access track would just be another small field, wouldn't it?
It would subdivide the field, but it wouldn't escape the fact that the development was then within 160 metres of the national landscape boundary.
Sorry, Mr. Cottle, I just need to be clear about the premise of your question. Are you suggesting landscaping could go across from site A, B to site A? I thought that's what you said.
That's right, from B to A, that's right.
But they're not next to each other.
From the vegetation behind appeal site A.
I mean, it's
But
also the
there's
fact
no-
these
there's
are
no
outside
link.
the red lines, so.
You're talking, I don't understand that, given the plans.
It's from the back of appeal site B
Yeah.
across towards site A.
But that's not part of the appeal sites.
That would be a question of obligations, wouldn't it? I think they would continue just adjacent.
They're not.
There's nothing before me at the moment to suggest that that's practical.
Across the back of the site for the time being. Obviously, any additional planting outside of the site and indeed on the boundary to Dunsfold Road would depend on an obligation from a third party. But a line of trees in that location would not be out of place for the local landscape.
Depending on the species, etc., a line of native trees in that location wouldn't appear in and of itself would not be incongruous, but that's not what's before the inspector, and it's outside of the appeal schemes. Nevertheless, you get the negative effect, and I mean if you turn up the original appeal B statement of case, which is CD 2B.2. CD 2B.2. And so now you've got it. If you turn to page 28 of the PDF, you'll see two images.
These are the photographs.
These are sort of oblique images of what looks like B, C, and D. The heading at the top of the page, sir, is intrusion into the countryside. Page looks like this, sir. So if we look at the bottom image, this is precisely my point about the projection. This is the appellant's submission. This is what they are proposing. And as you can see, you have Lydia Park, you have the clearly defined access track, and then you have these schemes projecting out towards the national landscape. This is precisely what I mean about the incongruous pattern of development, about the projection towards the national landscape, and about the incongruous shapes and forms within this landscape.
The incongruous pattern, as you put it, would not be perceivable from outside of Lydia Park, and the people who would see it would be the people in the caravans, and it would be their views.
I don't agree, because this
Just be
is
their views.
essentially looking from the direction of Hascombe Hill.
Well-
And whilst it would be more distant, I think, you know, it's my view that projection from Lydia Park would be visible.
It's entirely impossible to suggest to this inspector that any new planting would be visible from the Hascombe Hill path. Just be impossible to discern the new planting.
But you don't have any visual evidence to actually make that point. It's just a, you know, it's a conceptual thought. The only visual evidence you have that I see is presented on this page 28.
No, on the contrary,
which
Mr.
shows the
Dudley.
units being visible above planting on the boundary.
You've been up that path. The inspectors might have been, but he's going to go up there again. And he will know that looking down towards the Lydia Park, it will be impossible to discern any new planting around the outside of the appeal site B.
I disagree that he'll know that. I think you're prejudging what the inspector will perceive on site. I've been there. I'm saying that I've stood in that location, and I'm saying that's not the impression the inspector will get.
Just on the last point, your third reason about the planting was that looking down from above.
Yes.
But it was the planting that was relied on in the other decision letters for saying there was no relationship with the setting of the A and B, wasn't it? It was the planting of trees.
I'm not sure, but what I do know is that Lydia Park will have been visible above the wooded stream corridor at that time.
Wasn't seen as material by the inspectors, but we'll move on to a different moment. Just before finishing this subject, can we agree that with proper specification of planting, with proper implementation of landscaping, with proper irrigation, with proper aftercare and maintenance, conditions landscaping can succeed?
Not on these sites, no. In my view, the soil's been irretrievably damaged.
You're wrong about that, Mr. Dudley, because you know perfectly well that there are areas around the edge. I mean, I think we've got it from Mr. Sibbott that there's butterflies that are protected species that he's found some particular plants on the appeal sites which they're feeding from.
Plants. Yes, but what we're talking about is trees and shrubs. We're talking about woody vegetation.
Well, perhaps I can just leave this subject in relation to your statement, where you're saying that the site would be entirely rendered to hard standing, and we're saying that there would be landscaping and hedges.
I've recognised the presence of the hedgerows in there. That's in my proof.
Right.
But I think those hedgerows couldn't be established now. I think the soil is too damaged because the entire area in which the hedgerows are proposed to be located has been compacted, contaminated and waterlogged.
It's just that your paragraph 217 says the opposite. It says the entire site is proposed to be laid to stone hard standing. That's why I asked you the question.
I understand that. My figure 2 has the submitted site plan, which includes the hedgerows, and I recognise there's a slight conflict with that statement, but nevertheless.
All right. Well, I'll move on to a different subject, and it's
Okay.
It's to do with the area of greater landscape value, and I'm sure my lane friend Mr. Masters is going to come back on this. But if you can look at paragraph 2.2 and 319 of your proof, please. Paragraph 2.2 and 319.
Yep.
And the exception that I'm taking, Mr. Dudley, is to the use of the word therefore.
Mhm.
where you use it in this sentence. The site is located within an area of greater landscape value, and therefore, based on this designation, my analysis is, in my professional opinion, is that the landscape which the site is located in is a valued landscape. And then again, in paragraph 319, you say the same thing, which is that given the designated status and the fact that the site and its setting are moderately or strongly representative of the published landscape character at all levels, I'm confident that the site is located with a valued landscape for the purposes of the application of paragraph 180A, and therefore there is a national policy obligation for this landscape to be protected. And the point that I'm putting to you is that it doesn't follow, because you have to do an area specific appraisal as to how a proposed development is going to fit in with the local area. Just because it's designated doesn't mean that it's necessarily valued.
Well, I'll take you to my exact wording. I mean, I think the fact that it's in an area of great landscape value says a lot. But I've said, based upon this designation and my analysis, it's my professional opinion that the landscape is located in a valued landscape. And then if we go on to 3.19, I say that given the designation and the fact that the site and its setting are moderately or strongly representative of the published landscape character, recognising the fact your witnesses have failed to even recognise the published character of this landscape, I'm confident the site is located within a valued landscape, and going on from that, and therefore there is a national policy obligation for it to be protected and enhanced. So the matter at question with the word therefore is whether there is a national policy obligation for valued landscapes to be protected and enhanced, which the clear answer is yes, based upon the wording of NPPF.
And the inspector is entitled to say that this field, which the appeal site is part of, does not exhibit or strongly exhibit the characteristics of the local character assessments we've got it WW5, haven't we?
Yes, the inspector is entitled to form his own judgments. But you know, in my view, the inspector has credible evidence before him, from my part, on whether the site constitutes a valued landscape, and he has no commentary from the appellant on whether the site contributes a valued landscape, but he can form his own judgment.
If we look at your paragraph 3.5, please. You say, paragraph 3.5, that the site shares a relationship with the elevated land of the Wealden Grand NCA to the north, and in particular Hascombe Hill, which forms a topographical backdrop to the north as illustrated by figure 5 above. Mm-hmm. And the way I heard your evidence is because you could see the national landscape, there was that relationship. That was it. It's
the most clear element. The other point is geography. It's within 160 metres of the national landscape. But if the site generates noise, you will hear it on Hascombe Hill. So its perception is about all of the senses, and it's about what you experience as you pass through a landscape.
Exactly.
And so, yes, my evidence is that the site forms part of the setting of the national character area.
Well, if we go back to...
There is no evidence from your witnesses, only a refusal in the statement of common ground to agree that the site's within the setting of the national landscape.
If we go back to your figure 8, which is the view from the national landscape, the closest point of the footpath, the inspector could decide that given the limited, or the struggle that he's got to see the appeal site, that there isn't that relationship.
That's for the inspector to determine. He has one set of clear, transparent evidence before him.
And then if we look at your paragraph 3.8, please. You're talking about the wooded, low, wheeled landscape type.
Yes.
And we know that that's subdivided into I think 9 different portions, is that right?
Somewhere in that region.
And we've got WW1 through to WW10. It's actually 10 different areas.
Yeah.
So you're not saying that it exhibits characteristics of all the different geographical areas, because landscape type wooded low weald is divided in the landscape character assessment, and you've looked at the overall character and said there's a strong representation, as I understand it. But why don't we just look at the particular character areas, WW5?
I have. It's in
What does it
evidence.
add to have this categorization under wooded low weald landscape when we've got the subdivision to work from? Why don't we be more accurate and just work from the particular area it's in?
I'm going to take you, sir, back to paragraph 5.12 of the Purple Book that we reviewed earlier. And that key sentence, paragraph 5.12, it's on page 77. And that key paragraph this key sentence, reads: the first step in preparing the landscape baseline should be to review any relevant assessments that may be available at different levels in this hierarchy. So it's important to consider the different levels of assessment, which is precisely what I've done. I've considered the national character assessment, I've considered the landscape type, and I've considered the landscape character area. Again, I remind you, your witnesses have failed to even recognise the existence of the Surrey landscape assessment, or indeed the national character assessment. What the inspector's got in my evidence is a clear assessment of the key characters of those different scales of assessment within the hierarchy, looking at the key characteristics, their level of representation, an overall judgment, which then feeds into my assessment.
The way I read the landscape character assessment is that it gives an introduction and then it goes into the different geographical areas. And so I would be surprised if you hadn't addressed the geographical areas, which is the important point. And when we get to your proof, we see also that at paragraph 314, you start dealing with WW4, which is the Pinks Hill to Park Hatch Wooded Low Weald, which we discussed this morning. And it's on page 132 of the Waverley Borough Landscape Character Assessment. But the appeal site isn't in WW4, is it?
No, it's not, but that's utterly irrelevant, whether it's in or not. The site shares a landscape relationship with WW4. As I've recognised, I'm not seeking to mislead it, I've recognised in my evidence, the site is located in WW5. That's been analysed first. And then I've identified that the setting of the site to the north, which therefore makes it a valid consideration, is in WW4. My assessment, you'd be equally criticising me if I hadn't considered the character of the perceptual setting of the site. And I would, I'd agree with that, because my assessment would be deficient if I didn't look at the character areas that the site also has a relationship with.
Mr. Dudley, you have said that the appeal site strongly represents the characteristics of an area which it's not in.
No, I haven't.
And when you come to deal with
That's
the
not
area
true.
that it is in, you say it's only moderately representative. And it's not a question of just having a relationship with the Pink Hill to Park Hatch Wooded Low Weald. You, in paragraph 315, have said it's strongly representative of an area which it's not in.
You're misquoting me. What I've said is the site is strongly representative of the published characteristics of the landscape type. I can defend every single one of those. I've said it's moderately representative of the character area that it's within. And if we look at the exact wording of my paragraph 3.15, I say the setting of the site to the north is considered to be strongly representative of the Pink Hill to Park Hatch. My wording is very,
Well,
very clear in how I've dealt with this.
The north of the Dunsfold Road is that area.
Yes.
Right. So why don't we just say north of Dunsfold Road is that different area?
It's the setting of the site to the north.
So it only moderately affects the character of the area that it's in.
And actually, I take you back to my paragraph 3.11, because again, you're misquoting, maybe you should have read this better, because it says, while, end of paragraph 3.11, while the land to the north beyond Dunsfold Road lies within the Pinks Hill to Park Hatch. I have said it. And frankly, this is wasting appeal time, which is fairly limited today, on matters that aren't correct.
So you've said that it's moderately representative of a character area it's not in.
No, I haven't said that. None of this is true.
It's strongly representative of the Pink Hill to Park Hill wooded low wheeled character area, but I'll leave it at that.
Please do, yeah.
The point is that when it comes back to the Grafham to Dunsfold character area, the appeal site is not altering the main road that's crossing the area, the 281, which runs north-south along the western boundary before crossing through the central portion of the character area. It's not altering the Grafham House and its former stabling at Coach House at Grade 2 listed buildings. It's having no effect on the wider landscape at all, is it?
I disagree. That it's not having an effect on the wider landscape at all. And what it is having effect on is more sensitive elements, like the good network of public rights of way.
Would you agree with me that
and indeed the views towards the wooded green sand hills?
Would you agree that the visual views from Dunsfold Road are affected by the duration of the driver who's driving down there? That's actually a short glimpse.
That's only if you only consider the driver and you only consider vehicular users of Dunsfold Road.
Well,
there's a number of public rights of way. In order to undertake the circular walk I've proposed, we would need to walk along Dunsfold Road. Dunsfold Road can be used by pedestrians, cyclists, horse riders, and so
the majority of views will be from somebody who's driving a car and glimpsed views.
Is that your evidence? Because it's
no, it's a matter of common sense.
Because you have no evidence to back this up.
No, Mr.
There is
Dudley,
no evidence presented by the appellant on any of these matters.
Listen, Mr. Dudley.
And you've shifted from landscape to visual. This is my landscape baseline.
The sensitivity of the receptor is different between somebody who's standing on the top of Hascombe Hill and somebody who's driving down Dunsfold Road.
That's reflected in my judgments. I can take you to my visual analysis and show you the different sensitivity scores, and that's exactly what I've done.
Well, I put it to you that you're attaching too much weight to the views from Dunsfold Road, and actually those views from Dunsfold Road could be mitigated by landscaping.
I disagree, and the sensitivity I've attached to the users of Dunsfold Road is medium.
And one of the things you also did in your proof was to refer to a Grattan Chase decision letter. And I've counted the differences with that decision letter, and there are so many, I couldn't count them all. But why do you refer to the Grattan Chase decision letter as supporting your analysis of this effect of the appeal site on the wider area?
Where is that, please? Remind me where that is.
Paragraph 2.
He's asking what
I'll just give it to
letter
you.
number.
decision is one that you referred to. I think it was 2.3. Okay, well, you'll have to forgive me on that
It
because
is in 2.3, you're correct.
Well, 2.3 the proof.
2.3 of my proof.
page 9. And I'm putting to you that you actually misread the decision. It's fact sensitive.
Can we turn up the decision because
So poor. There are so many
CD9
differences.
So do you want us to go to 9A.1 then?
Indeed. And the inspector,
I think the
sorry.
numbers have changed.
yeah, I've got that's
Is it now 11? No.
yes, sorry, that's that reference within my evidence is out of date. Apologies.
Yeah, I think I found it. 11B.1.
Yeah, it's 11 whatever letter point.
Yeah.
one. You're correct, sir.
Okay, I found it.
and the point that I'm putting to you is that it's a very poor comparison because there are so many differences between that decision and this case. And that decision is in fact fact sensitive. And there's nothing that this inspector can take from it.
I'd need more information to because in my view it's in paragraph 9 I've picked up a general commentary on the relative value of the AGLV.
But that was particular in the context of that case. What we've got here is a field that has no national designation, that's described by Mr. Sibbott in his evidence. And your best point is that it's next to the AONB, isn't that it? And therefore it's valued.
No, that's not true. My points are, as we've already been over in my evidence, but I'll repeat it again. My points are, it's within a designated area of great landscape value. It's within the setting of a national landscape and in and of its own right.
Well, where we disagree really is about the effect of the magnitude of change and actually how the landscape can cope with extra caravans in that location. You're saying it's higher, and we're saying it's lower.
But you're not saying anything. There's no judgments. Okay.
Well, we'll put it like this.
I'll put it
Mr.
to the
Dunn.
inspector that you have one clear and transparent assessment of the effects of these schemes on the landscape and visual elements of this case.
If we had a supermarket there and not a caravan, would it still be major?
Yeah.
Because I'm putting it to you that in fact it's lower than major.
You can put it to me, but I've set out my judgments. This is my professional opinion. So you can put alternative, opinions to me, but I'm not going to agree.
It's actually limited harm because there are no views of the site in the wider area.
And that is the extent of your evidence, that it's limited harm. I've set out 4 clear proofs of evidence that set this out in accordance with structured guidance, and you have a statement that there is limited harm. I naturally disagree based upon all this work that I've done, all of this consideration that the inspector has before him.
And in relation to the effect on the national landscape, that is a relationship, but you struggle. You'd be struggling to see, the inspector will be struggling to see the appeal side.
The inspector can make their own decision when he undertakes a site visit.
I've got no further questions, thank you.
Thank you, Mr. Cottle.
Thank you. Thank you for coming in within time, Mr. Cottle, as well. So we'll take the break now. Resume. Can have 10 minutes. Come back at 3:45. Then questions from Mr. Masters.
Thanks, sir.
Mr. Masters, are you happy with me sat here, or would you like me to move around a notch so I'm
Um,
slightly more
I'm
facing
happy.
you?
It's you that's going to have to turn. So if you
I will
wanna-
sign a waiver against a cricked neck.
So if you want to move around, you might find it more comfortable.
Okay,
Okay.
thank you.
Okay. So I don't, but I think if I were you, I'd move around.
Yeah,
Okay.
yeah. Okay, I'll perhaps move to this chair then, if
I
sir,
just thought so. I
if
know
you're happy with that, so
I know you're
it perhaps makes
your
more
barrister,
sense. Well, that's okay, because I don't have, I can't interact with Mr.
No,
Lintoff
no,
at
I
the
was
moment
thinking
anyway,
the
so.
disadvantage is your head, but he probably doesn't want to see me anyway.
Well, that's-
Easy does it, Alan, easy does it.
it's a matter of screening.
I know. So I'm fine with that. So,
I'll move along a notch, that'll make life easier for everyone, I think, so.
yeah.
Advantage of a round table.
Could everybody take their seats, please? It is 1:45 and time for the inquiry to resume. Thank you. Mr. Masters, your opportunity to ask questions now.
Good afternoon, Mr. Dudley. Mr. Dudley, I've cross-examined you now quite over a length of time. You know that I'll ask you a question and give you time to make any caveats, but I would like a yes or no answer. And just so that we understand each other, okay, I'm testing your cross-examination. I'm not testing evidence from my witnesses. So I'm not going to let you get away with the answer you've given a lot of times. Well, there's no evidence against it, okay? Because it's the purpose of cross-examination is to test what you're saying, okay? So that won't get anywhere with me. I'll just throw it back at you and tell you to stop. So don't do it, okay? So let's start by the by the question of valued landscape, okay? Now you may remember, however you put it in your proof, the inspector asked you about this, and he asked you whether or not, at least I believe he asked you whether or not you'd followed the guidance in Libya and the technical advice about how you should assess a valued landscape, because it's not automatic in Libya, is it? But because something's designated as a valued landscape, but that's it. You've got to go through a process, haven't you?
It's a matter of judgment. The guidance is very clearly includes in the title outside designated landscapes.
Can I ask you again, okay? When the inspector put that to you, he referred to box 5.1, which I'm not sure what that is. Perhaps you can tell me.
I can indeed, if you like.
Yes,
Yeah.
please.
So box 5.1 is an example set of value criteria that you might use to assess the value of a landscape.
Is that the technical note?
No,
No.
it's been superseded by the technical note.
Oh, okay. Thank you. Because that's what I was thinking of, but I didn't realise it'd been superseded by.
I think for completeness, what Mr. Dudley said was that there was quite a lot of overlap between box 5.1.
There is
the
indeed.
technical note.
Yeah, that's right.
Okay.
Yeah, things, elements such as condition, associations, tranquility.
But I recorded carefully what you said, and you said, no, I didn't do that, because as far as I was concerned, because it was designated, that's all I needed to do. That's what you said, and I recorded that, okay?
Yeah.
And that was your answer, okay? And that's the answer that you gave to the inspector in the inquiry you quote, because again, it's Willow's inquiry, and you referred to, I think, paragraph 48, didn't you? Where let's record what it says. Given the long-standing inclusion of this land within the AGL designation, it is clearly part of the valued landscape. And what you told, in fact, the learned friend, and again I recorded it, is that the inspector took that from your evidence.
Yes.
Right. And we know the inspector was wrong because he didn't go through technical note or box 5.1, did he? Because according to because he took it from your evidence, he didn't need to do that. But that's wrong, isn't it?
That's the inspector's position to draw.
Sorry, that's wrong,
his
isn't
own
it? Could you answer the question? Remember, I said answer the question first and then give your caveat. That
It's
was
not
wrong, wasn't it?
I don't think it is wrong. I think the inspector is at liberty to draw the conclusions that that he does from the evidence before him. But I think in a designated landscape, considering the methodology for assessing the value of a landscape outside of a designated landscape wouldn't be the appropriate approach.
Right, let's start again, okay? It's wrong merely to assume because something is a designated landscape, it's a valued landscape. You've got to go through a proper analysis, haven't you?
I disagree. I think if a landscape is designated as being of great value, it stands to reason that it is a valued landscape. It's valued because of, or it was designated on account of the fact it's of great value.
Thank you.
So that exercise has already been undertaken in the consideration of the designation.
Okay, so you're saying, so I understand it, because I want to be clear, but because something is designated an area of great landscape value, automatically it's a valued landscape for the purposes of section 187A of the MPPF. That's your case, isn't it?
Yes, it is.
Thank you. And we say that's fundamentally wrong, and that's not what Livia says. Livia says go through the analysis.
Where
You
does it
don't.
say that?
I've already taken to you. That's what I say box 5.1 of the technical note requires you to do.
There is, hang on, box 5.1 is in the purple book.
And the
The technical note has a separate table, and I don't think either of them say that.
I'm sorry, you've got to, the references to the technical note make it quite clear, but you've got to make an analysis merely relying on the definition is not good enough. That's what I'm putting to you. If you don't agree with that, then you can say it, the inspector can make his own judgment.
Okay, I disagree on the basis I don't think that's in the technical note.
Right, that's the case I put to you. At any, if I may say so, landscape architect doing their job would not merely rely on the designation, but then let's look at the designation, okay? Because so that we both understand itself, the designation AGLV is a very old designation, isn't it? It was around long before the national planning policy and the concept of the valued landscape.
Let me see. So the, I don't suppose you know the date of the local plan, do you?
I don't.
Can anybody assist me with the date of the local plan? If not, I'll look it up in the core documents.
You just have to look at CD 6.6.
6.6. Thank you, Mr. Lintop.
Don't you know this? Don't you know that the designation AGLV has been around for a long time and it's in fact about to be retired?
Well, the designation was most recently considered in the local plan.
Sorry, I didn't
Because
ask
it's
you
a local
that.
plan
Could you
designation.
answer the question, please, Mr. Dudley? I said, answer the question and then you can put your caveat, okay? The designation AGLV has been around for a long time, hasn't it?
Yes.
Thank you. Long before the national planning policy statement and the use of the term in that statement in paragraph 187A, which it is now, wasn't then, of the term valued landscape. That's something new compared to the AGLV, isn't it?
I don't agree, because the designations are reviewed whenever the local plan's remade, and the local plan was most recently remade in 2018.
I'll try again, okay?
You'll get the same answer.
No, I won't, because I think you'll actually listen next time and answer it properly, okay? The National Policy Framework postdates by 20 years the first use of the designation AGLV, doesn't it?
Yes.
Thank you.
The first use of the designation,
Yeah,
yes, it
thank
does.
you.
But that doesn't mean that the implication of your question was that therefore the making the designation.
Don't double guess the implications of my question until you get it, okay? Which is now
Mr. Masters, you made a great point of saying that you'd like an answer, but then you'd allow a caveat. Allow the caveat.
I did, sir.
Well, you're interrupting before Mr.
If you say
Dudley's
so,
finished.
I thought I had waited. Is there anything else you wanted to say? I thought you'd finished, Mr. Dudley. I really did.
Well, allow me to summarise.
Okay, carry on.
Acknowledging that the AGLV designation was originally made some time ago, it was most recently made when the local plan part 1 was examined and published in February 2018.
But the use of the term
And that postdates the NPPF.
the use of the term value, landscape, great landscape value, predated the concept of valued landscape in the NPPF. They're not the same, or intended to be the same terminology, are they? Because GLVA existed long before the concept of a valued landscape in the NPPF. There's no, that's correct, isn't it?
The AGLV did, but the terminology, local landscape designations are used the terminology is used interchangeably. Sometimes we have special landscape areas, sometimes we have AGLVs or, other definitions, but basically it's an assessment or an identification of the relative value of a landscape within a district or borough.
Where do we find anywhere in the NPPF a reference back to the AGLV as being a valued landscape per se without anything more?
Where it says in a manner commensurate with the local plan.
A manner commensurate, that doesn't say what I asked you. Where does it say a valued landscape includes all AGLVs without more, anywhere, in any document?
It doesn't say that.
No.
It says that valued landscapes are to be protected and enhanced in a manner commensurate with the local plan. The local plan is where the AGLV is enshrined.
Yeah, but sorry, we're talking about the concept of valued landscape of 187A. And you've already said it's interchangeable.
If it's AGLV, then automatically it's a valued landscape of 187A. And I've asked you, where does it say that in any document? In any planning document?
In my view, that's the purpose of the phrase within MPPF 187A.
Yeah, and I tested that by making the point that the phrase in the AGLV postdates the MPPF first version of it by some 20 years and couldn't have possibly anticipated the AGLV phrase, the MPPF 20 years later and the phraseology in there. It's just a coincidence.
I think the MPPF specifically, that line was designed to capture all of these locally designated landscapes, be they AGLV, special landscape areas, or other forms of local landscape designation, and to set them aside from the remainder of the countryside.
Now you're aware, because I put it to you before, case law on this. The case law makes it quite clear. But the determination as to whether something is a valued landscape, one at the end of the day is for the inspector and no one else. But more importantly, it's a matter for the decision maker taking into account all the evidence and coming to an assessment. That's right, isn't it?
Yes, it is.
Right. So are you telling me that the inspector has to make the assessment it's a valued landscape just because it's an AGLV?
I'm telling the inspector that my evidence to him is that the site is located within an AGLV and within the setting of a national landscape, and that qualifies it to be a valued landscape.
So the answer is yes. The inspector has no discretion. He won't come to his own conclusion because it's in an AGLV. I think you just did.
I didn't.
I'm sorry, you interrupted me. Don't until I finished. I'll put it to you again. Are you telling me, I'll put it to you again, that merely because it's in an AGLV, the inspector has to come to the conclusion, as the other inspector did in Willows, that it's therefore a valued landscape?
I'm saying the inspector can read my evidence and form his own conclusion, but I've certainly not experienced an appeal within a designated landscape where it hasn't been found to be a valued landscape.
Okay, let's
That will
hold
be out with my experience to date, and my evidence to the inspector is that this landscape is valued for those reasons.
Okay, let's hold on to that because I think you've reinstated the point you made to Inspector Willows that as far as you're concerned, they're synonymous with one another. Okay, that's the point you've said now a number of times. If you're wrong about that, the inspector's entitled to take the view. You're wrong about it. I don't see an inspector is going to take the view that his discretion is fettered in the way that you suggest. Do you understand? But if you're wrong about that, then that does reflect on your evidence generally, doesn't it?
To some extent, it could have some bearing on my judgments of value, of baseline value of the landscape.
Okay, thank you. That's very helpful.
But then again, my judgments of baseline value are not based on the fact that it's a valued landscape under MPPF. They're based on the fact that it's in an AGLV. And so otherwise it's putting the cart before the horse. I'm saying it's a designated landscape. It's in the setting of a nationally designated landscape, and therefore it's a valued landscape, not the other way around. And so my value judgments within my proofs are based on the fact that it's in an AGLV in the setting of a national landscape. It's the same piece of information coming in.
Can I ask you that when it comes to assessing a baseline to start with, does common sense play a part in that?
Professional judgment is the primary consideration.
So common sense doesn't play any part?
I didn't say that.
Well, can you answer the question then? Does it play a part or not?
Yes, it does.
Thank
in the
you.
say way that it applies
Okay.
to any other
So
profession or other discipline.
Look at this site, okay? What's the predominant feature of this site? Both sides of the road.
What's the predominant feature of this site?
Yeah.
The fact it's countryside.
No, the predominant feature of this site is that there are a lot of caravans, isn't there?
I'm going to have to ask you the same question as I asked Mr. Cottle. When people talk about
This
this
site-
site in the context of appeals, I take it to be the appeal sites.
No, sir, did you not hear? I said both sides of the road.
I did hear that.
Yeah, and so I widened it on that very basis. If you like, there's a cutting, both sides of the road, the field and Lydia Park. Okay, what's the common feature of that area?
There's three, as expressed in my evidence.
Rubbish. As a matter of common sense, it's the caravan site, which is the predominant feature. In terms of character of that site, that area, both sides, what's the predominant feature?
One, I don't appreciate my professional evidence being described as rubbish. Two, Lydia Park is one of three characteristic elements within this landscape.
Could you
As
answer the question,
expressed within
Mr.
my landscape receptors. I am answering your question, Mr.
Can you answer
Masters.
it first? I said, what's the predominant, caravans are a predominant character of that site, isn't it?
No.
Okay,
Well,
we disagree.
caravans are a predominant feature of Lydia Park, but that's not the site we're dealing with. And Lydia Park is separated from the majority of our appeal sites by a belt of trees.
Okay, I'm gonna start again. Okay, in terms of that local character, both sides of the road, predominant feature in terms of character and development is a caravan site, isn't it?
You've just had an answer to that question, Masters.
I wasn't satisfied with the answer. I'm entitled to test it again.
Then
sir.
I'll answer again. No.
Okay, thank you. So I know that that's your position. If the inspector disagrees, then again, it'll be a matter for his judgment as to how much he can rely on your evidence. Okay.
Yeah. If
So
the
let me-
inspector can determine that the predominant feature to the north of the access track to Lydia Park under the correct baseline situation is caravans, despite the correct baseline situation being an open field, then he's entitled to draw that judgment.
Sorry. Lydia Park was there and existed lawfully at the time of this development, wasn't it? So it was part of the baseline.
Lydia Park was part of the baseline, yes.
Thank you.
To the south of the access track.
Thank you. No, yes, to the south of the access tract. So in terms of the baseline, one of the elements you would have to include when analysing the baseline is the lawful existence of Lydia Park.
As I've done.
I'm sorry, where in your evidence do you refer as part of your baseline to the existence of the, and in terms of character, to the predominant feature being Lydia Park and the caravans?
I'll take, so if you turn up for example, my appeal B proof, paragraph, well, let's begin with paragraph 3.30 actually, because
Could you go
this-
to your appeal A proof? Because that's the only one I've got. And I don't
It's in the-
represent,
it's in the
I don't
full
represent
documents.
appeal B, so just go
Okay,
to,
in that case, yes, by all means.
go to appeal A, thank you.
So this is paragraph 3.28 of the appeal A proof. If we begin there, so let me know when you have it. Excellent. So, Mr. Masters,
Yeah,
you've got it too. So here, this is the point I just made. The site's wider landscape setting can be broadly characterized into three types. The settled area of Lydia Park, immediately south of the site, wooded low-wheeled countryside to the south and east, and the steeply rising land of the Surrey Hills, AONB as was, to the north and west. Next paragraph. Lydia Park is an extensive gypsy and traveller site that's contained by the site's access tract to the north and Stovolds Hill to the west, and existing woodland to the south. So, yes, I do consider it as part of the
I
landscape
didn't ask you whether you
baselines in
considered,
writing.
I didn't ask you whether you considered it. We know that you referred to it. I asked you whether or not, but it was the key feature of the baseline to start with. And you said the key feature to the baseline to start with was the open field, okay?
Of the site.
Was what
forgive
you
me,
asked. No, I asked
And
you
so I
about
asked-
both sides of Lydia Park, of the road. So please don't misrepresent what I've said, because I know precisely what I said. And don't change your answer purely because of the point. So let's just stick with the baseline, okay? I say you haven't properly analysed the baseline because you haven't analysed the effect of Lydia Park on the baseline or made a judgment of that in any meaningful way. Because let's just go back to it. Okay, it's good to start with landscape character assessments, but none of the landscape character assessments have as part of their assessment caravan sites, do they?
No.
Okay, because they're so old. They were before any caravan sites on Lydia Park when the terrain was entirely different from the reality of today.
I'm not sure when Lydia Park started.
Well, I did the very first site in Lydia Park, and I think it was about 25 years ago. Yeah, I did. I mean, I can
Okay.
go back to
But
it.
I believe the Surrey Landscape Character Assessment's 2017.
Well, okay, then it fails to take into account um, uh, the area, or the reality is that these are always a broad brush, aren't they? So that they fail to take into account. Because of your cases, that this site is wholly within one of those two assessments. I can't remember which one you said, and partly in the other one. And I'm putting to you that this site, by the very nature of it and the granting lawful planning permissions that are permanent, is nothing like those assessments in character, because none of those assessments makes a feature of the fact that a principal character of this area is caravan site.
This is all reflected in my judgments.
Well, sorry, it isn't, because you give because nowhere in your judgment do you say that they're not reflective of the character assessments, because they ignore caravan site.
Sir, if I could ask you to turn up the section where I conclude my analysis of the key characteristics of WW5. So that would be.
Yeah, same proof. Sir,
I've any proof, sir. So let's stay with A, because Mr. Masters has a copy. Paragraph 3.13.
moderately
and
represent. Sorry, carry on.
It's my view that this counters the point that Mr. Masters was making, where I say, based upon the above analysis, the site and its setting are considered to be moderately representative of the Grafton-Stonesfold character area. The main source of incongruity relates to the presence of the existing gypsy and traveller site to the south of the site's access, which is a significant area of settlement and adversely impacts upon the tranquility of the area, which is why the bullet points above, some of them weren't highlighted, which relate to factors such as no significant areas of settlement.
Right, let's go to your 3.8, woodland low wildstone type. And we can see there's no reference in that type to caravan site. And then you say this at 3.8, considered to be strongly representative of woodland low wildlow landscape type. And I did say to you that it was in reference to one of the two, and I couldn't remember, but now you've taken me to see it, we know which one it is. Okay, and it can't be strongly representative with that type, because that type ignores completely caravan site, doesn't it?
It strongly represents the majority of the key characteristics, and that's my test.
Wait, forgive me. If it ignores the presence of a settled residential caravan site, it has no characteristics that one could argue were similar to the woodland low wildlow landscape tag, where it's predominantly lowland, undulating roughly 500 meters and blah, 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 includes significant amounts of tree cover, etc., etc. Do I need to go on? No reference there to a lawful large-scale residential caravan site.
There isn't.
No. And so
Can I just ask you about your question, Mr. Masters?
Yes.
Do you mean the landscape time? Or are you talking about character areas?
character areas? Sir.
Because you're in a different part of the proof.
Yes,
Well,
I thought we'd move to landscape types, sir.
Landscape types
I was
is a
answering on
much
behalf of the
broader
Woodland Low
area.
Wheels.
Well, so I do mean types then, because that's
You
where
do
I
mean
wanted
the
to go.
type?
Yeah, I do. Because
Well, that's an entirely different area.
it
We've
is
been
an
through that
entirely different.
early
It's my
today.
mistake, sir. But the point is a good one in any event. I know that the type is a broader brush area rather than a.
This is the consequence of this pointed out in the
Well, you've got my point, sir. I say there's nothing in that type that covers this site or this wider area that has now become predominantly a caravan site, and it's not nowhere within that type. The point I'm making, sir, it's very difficult to see how this site could strongly represent that type. That's the point, and that's the point I'm questioning. So let's just go to another baseline factor. Can you help me where you refer anywhere in your baseline or in your evidence today until cross-examination of the three type buildings? And so you asked for those buildings planning permissions. I've now got them. And if you like, I can hand them up. could you hand them up? Okay, and we can start with the ridge heights of the buildings. Yeah, one for the inspector and one for everybody else. Well, Steve, will you mind not having one for the moment? Because I've got one for, I think I'm going to be one short. You can have mine in a second. Just so we, the inspector asked about the dimensions, so let me give that to him now, as I can take it from the. I meant the elevation, sir. I think it's 4.7 from the ridge, meters high. Yep. I think you'll find it described in the officer's report, which is the second document. Thank you. Yep. Okay, so substantially high documents, clearly visible from the appeal sites, aren't they? No one could miss them. Mr. Dudley.
The structures,
Yeah, the structures. Have you not been there recently to see them?
I've been there, last time I was there was in October.
So
I
did you
didn't
not see them?
No, I didn't.
Well, the inspector will see them. Take it from me, you can see them. And you can take it from Mr. Rowe, because when we had our very first site visit last year sometime, we could see them. Okay, so that's why he went on the exercise. And by the way, yeah, Mr. Rowe in his evidence has made various character assessments, just to say other people hasn't, and so has Mr. Woods. So, and I rely on what they say about character rather than you. It may not be a landscape character assessment, but that's no reason why it isn't evidence. So let me just go back. Why is 3 large buildings, 1 large building, okay, that's been granted planning permission? We'll come to where it is in a moment, okay? They're part of the baseline and they're part of the character, aren't they?
Yes, they are.
But you make no reference to them at all, do you? Not the first time in cross-examination I've about something you missed. I've asked you about, by the way, you know that. You make no reference to them, do you? You made no reference, and none of it, and you weren't taken to it in any way in chief, and which I'm sure the inspector noted.
Yes, it wasn't in my original, it doesn't look like it
No,
was in my original
No,
baseline.
so your
appraisal, but
baseline is totally incorrect.
I wouldn't accept
And
that.
your conclusions on the baseline are totally incorrect because you don't.
I wouldn't accept
because,
that either.
Well, I'm sorry, let me just finish. That's my submissions to the inspector because you haven't used your common sense and taken an obvious factor into account, which you agree is a factor that affects the baseline, doesn't it? Can you answer the
It
question?
does feed into the baseline, yes.
Yeah, thank you. So let's just follow that a little bit more in a different way. Can you pick up your location plan?
Yeah.
Okay. Now, your general proposition is relates to the A&OB and to the area that's not the A&OB, but that's in the proximity to the A&OB, that you call as part of the setting of the A&OB. Is that right?
Sorry, could you repeat that?
Yeah. Your principal point about harm relates to the A&OB, okay, and the area near to the A&OB, which you say forms part of the setting of the A&OB.
That's one of my receptors.
Well, it's the one you featured mainly on. And the A&OB, if we look at this plan, okay, covers the area of Handsome Hill down, all the way down the boundary of it's Stovolds Road, isn't it?
Yes.
Right. And so, for instance, okay, the Dunsfold Road and traffic movements on Dunsfold Road form part of the setting of the ANOB, doesn't it?
Yes.
Okay, not a tranquil setting because it's a very busy A road, isn't it?
Which road?
I thought it was an A road, Dunsfold Road. Am I wrong?
It's the B2130.
Oh, okay. It's still not. It's still a very busy road, sir.
I
Not a-
walked it and it wasn't particularly busy when I walked it.
Not a tranquil road. It's part of a busy road. Yes or no?
No.
Okay. So you say.
And that is a comment. I mean, I don't want to interrupt, but it's not really something. So you say it's like being at school.
It is unnecessary, sir, but I don't think it needs to be interrupted. Yeah, but I will try and resist, sir. So you put a ring around Dunsfold Road where the brewery site is, haven't you?
Yes.
Did you take a photo from that site?
Yes.
How could you? So where in your evidence do you refer to? Because you've. How could you therefore miss the buildings as part of your baseline when you were there taking photographs?
I interpreted them as part of Thatched House Farm.
But you would have seen the development. We've got a photo in Mr. Rowe's proof of the development, and you can see it from the entrance.
Yes. And I interpreted the structures as part of Thatched House Farm.
So you just ignored them.
No, I interpreted them as part of Thatched House Farm.
You didn't make any inquiries about the recent planning permission. And the fact, if you had seen the recent planning permission in relation to that site, which we've now got, you'll know there's no reference there to the ANOB, to the setting of the ANOB, to any concerns relating in that context. Is there? You go to Mr. Rowe's proof where we've got an analysis of what's said there.
Where is that? Sorry.
It's page 3.
Page 3 of this gross.
Yes. The proposed new storage, bottling and canning building will be a simplistic design with green profile metal sheeting to the walls and roofs so as to match the design and appearance of existing brewery buildings at Thatched Farm Home. Proposed buildings would each measure 10.8 metres wide by 14 deep with an eaves height of 3.5 and a ridge height of 4.7, which would be in keeping with the dimensions of existing brewery. Officers are satisfied with design, appearance and size of the proposed building would not cause material harm to the wider countryside, would not appear materially different agricultural buildings. So no reference to setting of the ANOB, just a complete acceptance that those buildings were acceptable. They got it wrong, did they, Mr. Dudley?
I think they should have commented. on
They
the
got it
national
wrong, Mr.
landscape.
Dudley. They got it
In
wrong.
my view, they should have commented on the national landscape.
So they got it wrong.
I don't think they got it wrong. I think they should have commented also on the national landscape.
That shouldn't have been granted planning permission because it would have affected the national landscape and the setting of the national landscape. Much closer to the ANOB on the opposite side of a road than our site, isn't it?
It is closer, yes,
Yeah.
to the boundary of the
Yeah.
A and B.
And much more visible because of the height of the eaves.
No,
Well, you disagreed. Do you take any photos of where you could see that site from any viewpoints?
Yes.
Of course. Oh, did you?
yes,
So you took an assessment of how the 4.7 metre high buildings affected the ANOB? Where do I find that in your evidence?
I took a photo from the entrance to it.
Yeah, I know that.
Hmm.
But where do you
But
make
it's
your
not my role
assess?
to assess
Where do you make
the impact of that on the A and B. That, if anything, should have been undertaken when the planning for that building was being
So
considered.
you made no assessment of that effect on the ANOB? Yes or no?
How do you mean assessing the
Did you make
effects?
any assessment of the effect of those 3 buildings on the ANOB and its
No, I'm
setting?
assessing the schemes before me.
No, thank you. So, and the schemes that you're assessing before you make no assessment of how the effect of those buildings on the ANOB affect your
I'm
assessment.
referring to the appeal schemes.
Yeah, I know. Just listen to me. You've made no assessment of how the 3 buildings affect your assessment of the ANOB because of their mere presence, because then you make no part of, you don't put them in as part of the baseline, do you?
No, I don't specifically refer to them as part of the baseline because I interpret them as part of Thatched House Farm.
Yeah, wrongly interpreted. Because you've already agreed they are part of the baseline. So we're not going to go back over that because the inspector can make his own view on that. So I'm saying to you, your whole baseline assessment about caravans and these buildings is wrong. Okay, let's just go let's just look at it for a moment, okay? In terms of common sense, okay? In terms of the wider landscape implications, the fact that you have views of caravan site and the fact that you have views of large buildings that are very tall, okay, are going to affect the visual views and also the landscape assessments that you've drawn, aren't they?
Yes, that's right.
Right, but you haven't made that assessment because we've already said that.
I have assessed the presence of caravans.
Well, okay, but you haven't done that for the buildings.
I've,
I'm-
as I said,
I'm
I've
going to
interpreted
beg-
them as part, I'm repeating myself now. I interpreted them as part of Thatched House Farm. We seem to be going in circles now.
No, we're not going in circles, but I accept you repeating yourself, and if you go in circles, that's a matter for you. I'll try and stick to the questions and see if I can get the answers. So, but let's just look at these four ringed photo sites, okay? Now, what you've said in relation to the views from them in winter and in summer is that they have up to a significant effect. That's what you've said.
I form my judgments, yes.
Yeah. So your case rests. I mean, these are very long, they're long distance views of the appeal site, aren't they? Seen in the context of loads of other things.
One of them is a long distance view. I wouldn't agree on the rest.
Well, I suggest that if they're not long distance, well, I suggest they are long distance views. They're not close distance views, are they?
I'd say some of them are close distance views, yes.
Well, which ones?
The ones that are close to the site.
Well, which one? I mean, of the four I've got, the nearest is Dunsfold Road.
Yeah,
Well, I suggest that, and that's a lot. I suggest that isn't a close view. A close view is along the road into the site.
I disagree. And I
And-
certainly don't agree that they're all long distance views, which was
Well,
your starting point.
I'm not going to argue with you about whether you agree or disagree. I understand you disagree, but I'm putting to you, at the end of the day, you see this will be a judgment from the inspector, won't it?
Yes,
Okay. And he'll look at these views and form his own judgment. And he's got to form the judgment that there's significant adverse harm caused by them, which is your case.
he doesn't have to form that judgment. The inspector will make his own judgment, but he has my evidence to inform him.
Absolutely. But so he has to look at what you're saying and decide whether he agrees with you.
Correct.
Okay. And that's why I suggested, and of course we say that's, I'll put the term again so you understand. We say that's nonsense judgment on any reasonable view. They're medium, in some cases, long distance views where you're getting glimpses of the site in the context of a wider site. And without binoculars, it's really difficult to work out what's going on.
That's your opinion. You're entitled to state it.
Well, I am.
Again, I take offence to my evidence being described as nonsense. I'm a chartered professional.
Yeah, I know, but I'm entitled to do that as a barrister, believe it or not. And I can put to you as to whether a proposition you're making is correct or not, and that's what I'm doing. And I'm entitled to test you that. Not because I'm trying to offend you, Mr. Dudley, you know that, but I'm trying to put a value on what you're saying. Okay, and if I don't put that to you and I put it later on, I'll be accused of not putting to you at the time, which is why I'm doing it. Do you understand?
I understand.
So please don't offence, because it's not
No,
offence.
but nonsense would imply that that there is no sense behind my judgments, whereas my judgments are based on a clear methodology that's in alignment with national guidance.
If it helps you, then I will put it in a more sensitive way and say that we say very little weight can be given to that judgment.
That's extremely kind of you, Mr. Masters.
So we both agree to disagree.
We shall.
But I'm not trying to offend you, which is why I stopped. Okay. Looking at this map, I'm not going to go over the area that's all you already asked with you, because you've been asked about fracking site. And actually the structures on the fracking site are going to be as high as the buildings. So they're going to form the drilling rigs, they're going to form they're going to have an impact, aren't they?
Yes.
And you didn't take account of that, did you?
No.
So they're going to have an impact on the baseline, another impact on the baseline you didn't take account of, did you? And just so everybody knows, they're in the field next to the brewery. And I know they were objected to, but they were passed very recently, in fact. It was a called in decision, wasn't it? Yeah. So it's been assessed by the High Court and found acceptable, even though it's much nearer.
So let's get it right. I don't think the High Court were assessing the planning merits.
The legality of it, sir.
It's a different point.
Yeah, okay, I take the point, sir, but the planning merits were assessed because they were accepted. I think by government. Because I think it was a decision, I don't know if it was called in or whatever. But the point is that the Secretary of State has looked at this area very recently, hasn't it, in terms of the fracking site and found no impact on the ANOB or in its setting.
I don't know, I haven't read the documents, so I couldn't say whether the
No,
Secretary of
well,
State
that's-
found no impact or low impact or whatever,
Yeah,
or
that's
indeed
the-
found significant impact and decided to overrule it on the basis of energy security.
That's the point, Mr. Dudley, about your assessment of impact on the ANOB. I say you haven't taken into account in the various aspects of the baseline, including that site, which have a material effect upon, are likely to have a material effect on the judgment of the inspector. Because
That's
he'll
the
have to
inspector's
take
decision.
he'll have to take into account the Secretary of State's recent view of a site nearby
He will.
and its impact, won't he?
That's correct.
Thank you.
I can only take into account material that's before me. I don't think that's before me.
It is, sir. I've just put it in evidence right now.
You've just put what in?
The fact that that decision happened, the fact that
What you've just put in are the documents relating to Thatched House Farm.
Oh, no. Sorry, I haven't put in any material. But what you have unmistakably is the fact that the Secretary of State found that site.
Where is
acceptable.
that? Is it a document I've overlooked?
No, sorry, it's not a document. I put it to this witness who's agreed it. It's a matter of
Yeah,
evidence.
it's
now.
not to you to put evidence in, is it, Mr. Masters?
Oh, it is, sir.
No.
No, sorry, sir, it is. What comes out of cross-examination, if it's agreed, is evidence that you must take account of. You can give what value you want to it at the end of the day. You might say, for instance,
You're asking questions about this to the witness. I've seen nothing to substantiate this yet. I mean, I'm happy for the document to come in as it's been referred to.
well, so we'll try and get it. We'll try and get it overnight. The fracking site decision, okay? We'll try and get it and put it in if you're happy with it. So since it's agreed by everybody, we'll do it that way. Okay, thank you. I'm sure the council will be able to assist.
Well, I mean, Inspector, it just comes back to the same point, really. I mean, obviously, we're keen to make sure you've got everything that you need to make a decision. There's a process for putting in evidence on the appeal. We're now in cross-examination of this witness's evidence. There was no supplemental evidence, no rebuttal evidence. These matters are obviously matters of fact and judgment. This evidence is obviously going to come in after Mr. Dudley has given his evidence. I mean, it's procedurally, it's difficult. I think all we can do is look and see what is provided. If the document is provided and it needs to be dealt with by Mr. Dudley, he could be recalled. That will be a matter for you to look at that stage.
So
But
the High Court
the first
decision was,
step is to have a look at the document, I think.
the High Court decision was this week, I think. Was it last week? So therefore, it was in abeyance. There was no point in putting anything in on it until we knew what the High Court decision was.
But what ought to have happened was at the outset of the inquiry, when the inspector said, are there any other additional documents that you want to rely upon, Mr. Masters? You should have said, well, there's a High Court decision that relates to the baseline that I don't think Mr. Dudley has considered, brought copies of it, circulated them.
Well,
We could have then dealt with it in
well, if the
evidence.
inspector wants to penalise me for not taking that route because I didn't know what the decision was going to be, and it's very recent, and I've now put it to Mr. Dudley, who accepts it. It's been referred by other people in evidence. Then he'll have to make a judgment as whether he wants that document. He's already said he's happy to have it. So could you supply it?
And I don't think he's actually agreed. He said he doesn't know about
And Waverley opposed the permission and challenged the permission.
So you knew about the document as well then, but you didn't put it in as part of the extra evidence that you were going to, I suppose you haven't relied upon it, so it's Mr. Masters that is.
My case is that the area
He's put that to the witness who agreed, by the way. So Mr. Dudley agreed to Mr. Cottle when he put it to him, and he agreed to me when I put it to him.
I suppose the first question for Mr. Dudley ought to be, has he read this document? Does he know about it?
Well,
before he agrees.
no, no,
everything.
the first question is that, it's a fact that this exists. It's a fact that if it exists, which Mr. Dudley accepts, that it forms part of the baseline. The question is, should the inspector therefore have the document? And in my view, he should. Are you opposing the inspector having the document? So it's on record. So if we go up to the
Well, I
court,
just
of-
said
Mr.
the
Lintott
opposite.
isn't opposing it at all.
right, so, but in which
He
case,
wanted to see it first, and that's fine. I'm content with that. And I think my record of what Mr. Dudley said, he agreed that the site that was put to him, I think, by Mr. Cottle earlier today, was within, I think Mr. Cottle was referring to a 2 kilometres distance, and Mr. Dudley agreed that it was within there. But in terms of what was decided, in terms of the outcome, my note is that he said he didn't know.
no, so, but he also agreed it was part of the baseline. And if, but as I was putting to him,
On the basis of what you put to him.
yes,
But you hadn't seen the document.
no, but the point
Anyway, we're going to make progress with that. So carry on with your questions, Mr. Masters.
So I'm not trying, I just want you to have all the facts at the end of the day that are pertinent. And I think if you don't have the fact of bearing in mind the case, is how significant this development is going to be on the surroundings of the ANAB, then it seems to me an important document you should see. That's why I put it in. Okay. Let me go back, if I can, Mr. Dudley. Sorry, but yeah, Mr. Dudley, you know me, I'm always doing this. There's always pauses where I'm arguing with an inspector or someone else about where we're going. So I apologise for the delay. Okay,
Not a problem.
but you know that's, with me, seems to be inevitable. Okay. I put to you, I'm just going back over it for a second, about the distance of the views, okay? Your principal case rests on two things, doesn't it? In terms of landscape harm, the long distance views, okay? And you say the impact in landscape terms of the development.
My case rests on significant adverse effects on 3 of my 4 identified landscape receptors and on all of my identified visual receptors.
Okay. I think that's a yes. Look, can we both agree, okay, that Mr. Cottle put a question to you about there being, about one of your photos showing a tree line that's no longer in existence between the site and Lydia Park?
No, Mr. Cottle put questions regarding a tree line that was within the site, which is being removed.
Okay, that's what I meant, but if I phrased it badly, whatever. And your answer to that was well, it's still relevant because it depends on whether or not there's been a breach of a felling license.
It's relevant because you can't reasonably take account of intentional unauthorized works as part of the baseline.
Well, I'm sorry, but
That's my view.
Well, no.
The inspector can disagree if he likes
Well,
and
sorry.
accept the sites as they currently stand. But my view is that the condition of the site prior to the commencement of any of these works within the appeal site is the correct baseline.
Right, let's just take it. So do you produce any evidence that there was a breach of the felling license?
No.
It's just speculation on your part.
It's my opinion, bearing in mind I'm a chartered forester, that there was in excess of 5 cubic metres of timber.
I'm not asking you that. I'm asking you, do you produce any evidence that there's been a breach of a felling license?
No.
There are various exceptions to a felling license which entitle somebody over 5 cubic metres to fell, isn't there?
Such as?
Well, I'm not going to go into them. We know, you should know what those exceptions are. Okay, there's no evidence that those exceptions didn't apply, is there?
No, there's no.
No. And in any event, a breach of a felling license isn't a landscaping offence, is it? It's a criminal offence on summary conviction.
Yes.
Okay, and you have to prosecute within 6 months, otherwise there's no offence.
Yes.
Right, and we know that this was done years ago.
That's
Okay?
right.
So forgive me, why are you speculating on whether there's been a breach of a felling license years ago that's totally irrelevant? There is no doubt that whatever happened when these trees came down, there can be no prosecution. They are not unauthorized development now, are they?
My statement is that the clearances of the site were unauthorised development when they occurred. They were intentional unauthorised development when they occurred.
Well, we don't know that. We've already said that. We don't know whether there was a felling license. We don't know whether there was part of the exceptions. But if they're not prosecuted, that's the end of it. There is no reinstatement clause in the prosecution, is there?
Sorry?
There's no reinstatement by the prosecution. It's a fine.
No, there is.
No,
It's a
forgive me.
statutory restock notice.
No, that's something that can be done by the local authority after the conviction if there's a conviction. Has to be a conviction.
The Forestry Commission would place a statutory restock notice.
If there's been
following
a
legal
conviction.
felling.
If there's been a
If
conviction.
there's been a conviction,
Right.
that's right.
And there's been no conviction, has there?
No, but that's not the point I'm making.
No, well, forgive me. So there could be no reinstatement. So your point is irrelevant as a matter of fact, because whatever happened years ago has happened. Can't be replaced. Nothing can happen with it. The lawful position today is that those trees weren't there. Were there then, but they're not. They can't lawfully be replaced in any way.
It's my view that the correct baseline for my assessment is that vegetation being present. That
Forgive me,
the correct baseline position of these sites is open field, wooded corridor and hedgerow.
Okay, that's just lacks common sense, Mr. Dudley, and particularly from you who knows that no way can these trees be replaced in any shape or form. Can they be enforced to be replaced? So what was there historically is irrelevant to the baseline at the date of your judgment and assessment.
I don't agree, because that's against the spirit of planning.
Sorry, where does the spirit of planning come into an assessment of baseline? I mean, it's a lovely concept. I mean, I wish I could do it all the day, because I would say it's against the spirit of planning that you should be opposing these poor gypsy guys who desperately need accommodation. But it's not going to get anywhere with the inspector, because it's not about the spirit of planning. It's about planning policy and judgment.
It's for the inspector to decide which is the relevant baseline scenario, but it's my case that the baseline scenario is that pre-development.
Well, forgive me. It's not
On the basis that the development is intentional and unauthorised.
Yeah, it's what the baseline was pre-development. And the baseline pre-development was not a site with trees on.
My argument is it was.
Well, and I've already explored that with you, and I say that lacks common sense. For the reasons you've agreed, that you don't know the circumstances in which the trees came down. They came down years ago. There was no prosecution. There can be no reinstatement. So that horse, I'm afraid, Mr. Dudley, has flown. And I say the inspector agrees with that, and he has to, based on your arguments, then that's another judgment you've made of the baseline that's flawed. Would you like to comment on that?
I disagree.
Okay, that's a matter for you. I put the point. Now, I want to come to short-term views of this site, okay? And by which I mean, not from Stovolds Road. I'm not sure, is it Stovolds Hills Road? Stovolds Hill, but I'm talking about the internal road that comes, because you can't see the site anywhere from Stovolds Hill, can you?
No.
No. So the only short-term views is when you come across the site in that sort of area of, that's much more open than Lydia Park on the opposite side of the road. But you see the site at that point in the context of Lydia Park, don't you? In the context of an established.
Mr. Masters, just want to be clear about where you're putting the short distance view from.
Can I do it, sir, from the plan? If we go back to the plan.
Yeah, I've got the plan.
Yeah.
Where are you? You've said it's not Stovolds Hill.
Yeah, if you, Lydia Park is that little, is a little area here, isn't it?
It's marked.
Yeah,
It's marked for the site visit.
and you can see, I don't know if you get it, I don't know whether you're actually see the,
I just realised actually my pink line going through Lydia Park is too far to the south.
It is.
it is, it's
It
not,
is.
the-
It should be the track that you see
Should be
sort
one
of
block
sitting
further north.
Yeah.
shouldn't it?
yeah, I
to the
think,
south of where the dotted line is.
I was
the
going
dashed
to,
line.
that's why I was confused, because I
Yeah.
couldn't see.
Yeah,
the
I
part-
just realised that was a, yeah, apologies for that, sir.
No, in fact, that pink line should be, at the top of the rectangle that Lydia Park is.
Should be
That's
along
what-
the watercourse.
Yeah,
Yeah, that's it.
okay. So I'm looking at that area, sir, as when I say the short-term views. You don't see it immediately, you come along that track. I think you go round the bend and then you see it.
That's right.
Talk about going around the bend, it's sometimes like that on days when I cross-examine. But anyway, sorry about that.
That's okay. I won't reopen the baseline can of worms by saying about glimpse views through a wooded stream corridor.
You did, but okay, I'll give you that one.
Oh, I just did. But yeah, we've agreed to disagree on that.
We
But
have.
yes, I would agree. Yeah, as you come along the access to
Okay.
Lydia Park, as you come into Lydia Park, you don't immediately see the sides. You'll
Right.
see C and D
Yeah,
first.
I mean-
and then you come along and see A.
I
towards the
agree.
end.
Okay, you're going to see the site at that point, but the PPTS makes it quite clear that the object is not to hide sites from view,
Agreed.
and in fact, to maintain sometimes. So that's not a particularly unacceptable view, those short-term views. Would you agree?
I'd agree with that.
Thank you. So again, we come back to the long-term views, which we've already discussed. I'm not going back on that because, and I'm not going to give you the opportunity to make any more comment on it either.
Very good.
Okay. So let's just pause there. Now, predominantly, if you go along that road, whatever your long-term views are and your long-term analysis, the character at that point is mobile home park, isn't it?
On the access track to
Yeah.
Lydia Park, yes, it is.
Thank you.
Yeah, Lydia Park is the dominant element within that
Yeah.
view.
Now, the council are in a difficult position, Mr. Dudley, because they've accepted all these sites in Lydia Park over the last couple of years. We know that a lot of the locals aren't happy with that. Okay, but they have a need for sites. Now we know that this district, I don't know if you do know, because I'm going to put you about 60% A&OB in green belt. Do you know the percentages?
I don't.
That's what I understand. I mean, Mr. Woods has put it in his proof as 50%, but I've gone and looked and it's over 60%. And I think Mr. Rowe will deal with that, okay, in his evidence. So I'll put to you what I understand. 60%, that 20% urban and the rest is countryside. Okay, so if you were if you had a basis for where you would put the sites, you'd put them in countryside before you'd put them in A&OB and green belt, because A and OB and green belt are a higher protection.
Yes,
Okay.
we won't talk about grey belt.
Well, no, we're not going to talk
Yes,
about. We
that's
are
right.
going to talk about green belt in a moment. Although this is, I see, this is not green belt, but only in another context. Okay. So, as I understand Mr. Clark's argument, is the council have got to draw the line somewhere, and they're drawing the line across the road because they don't want the site to expand any further. So, but that expansion and that policy decision about where the site should be isn't a landscape objection, it's a policy objection about the expansion of Lydia Park, isn't it?
I don't know.
Okay, well, I'll put that to him. But it can't form any part of your analysis, can it?
What's that?
The objection to the expansion of Lydia Park across the road in policy terms.
No, not in policy terms. That's
No.
right. That's a matter for planners.
Yeah. So it's not a landscape point, it's the point I'm putting to you. And I thought you'd agree
Yeah,
with me on that.
I can look at the landscape and visual effects of expanding beyond the road, but yeah, not in policy terms.
Yeah, thank you. That's very helpful. So, on again, if I could just clear up one or two things. The policy planning position has changed since the council granted base planning permission for Lydia Park, because there's been a new NPPS and a new PPTS that has changed the landscape in considerable ways and a new definition. Do you, and now when you made your first landscape assessment, it was on the old policy. You and you mentioned policy in your evidence, but in your further statement, I can't remember, it's called a rebuttal statement or whatever it is, but
The
there's no,
supplementary.
yeah, the supplemental thing. You make no reference to the changes in policy, do you? You probably didn't think that they affected the
Well,
site.
the landscape policies are identical. The only thing that's changed is the numbers.
Okay. But you see, what I'm going to put to you is that the climate's changed. The government is now more encouraging of development and less tolerant of objections that are there for the purpose of just delay and stopping things happening that need to happen. That's right, isn't it?
I wouldn't know.
Yeah.
I think that line of questioning perhaps is for Mr Ward
Yes, sir,
rather than Mr Dudley.
it is, but I need to. I will, sir. That's why I was going to go no further than that, as I did with the last question for that reason. But if this was a greenbelt case, then it would have a significant effect, because we'd be, if there's no 5-year supply, we'd be looking at a situation where this would be classed as appropriate development, wouldn't it, under the new policy?
I don't know.
This isn't, this line of
Okay.
questioning is not for this
Yeah,
witness.
I see. So you're right. My mistake for even trying. I'll move on. So, if I can, I want to go back to the individual sites. Now, I have a duty to all of my clients, and one of the points that you've made repeatedly, if I may say so, that particularly in terms of visual harm, is that there's far less visual harm in terms of Appeal A than in terms C and D.
There is a degree less visual harm,
Well,
not far less.
that's a matter of judgment for the inspector. I would say it's distinctly less.
Yeah.
It depends on the.
In summer, my case is that Appeal A scheme will not be visible.
I know.
In winter, we've now identified a degree of harm.
Well, yeah, and I said, and you say that's significant, and I say, look at the photos, and I beg to differ, but it's anywhere near significant. Okay, but
And we
the point,
naturally differ, but yes.
but that's where we differ in terms,
Yeah.
and of course, we're not. You would accept, can't you? Visual harm can be affected by mitigation, landscaping, and other factors.
Yes, it can.
Okay, and you haven't made any assessment of that, have you, in your harm? You've just taken the harm as it exists without any mitigation. We know that because we can read it.
Yes, well, I made a judgment based upon
Yeah.
the proposed scheme.
Believe it or not, I always criticise you for not taking into account mitigation. I hoped you would learn by now to have done it, but
It
you
just helps me
haven't.
to hone my arguments, Mr. Masters. I appreciate the practice.
But you haven't,
But, yeah.
and it's an important point. Okay, now do you accept that mitigation can improve your concerns about visual harm?
Mitigation can lessen the magnitude of change in visual terms.
That's a yes, isn't it?
So that's what I'll say.
That's a yes, isn't it? Mr.
It's
Dudley?
not the exact what you said, but that's what I'll say.
Okay, I'll leave it at that. In terms of appeals C and D, they're more into the open field. Would and you would say that they can be seen visually from more than one receptor, although
Correct.
and therefore the harm is greater.
The harm on those receptors is greater because they're visible from them,
Okay.
and there are more receptors that would be affected.
So, I'm not. This is not for you because it's elsewhere. But I mean, when the inspector assesses harm, okay, and this may be the inspector say is a question I have to put to Mr. Clark, but I'm saying that the harm is so little in relation to all of those, but the inspector can safely grant planning permission either for a permanent or a temporary. But the inspector there's nothing stopping the inspector coming to a split decision in this site and granting permission, some permissions for some full or permanent, and some for the others temporary or whatever.
That's right. The inspector has got separate proofs of evidence for each site
Okay.
for him.
So let me just put to you the difficult point. If we were just looking at Appeal A, would you really be objecting on landscape grounds?
Yes,
Really?
yes. My judgments have been set out in my proof.
Okay. Have you been to that site?
Yes.
Have you noticed the gate across the road?
Yes.
Can't go beyond the road from that point. Okay. It's almost literally connected to Lydia Park, isn't it? And it looks as though it's connected to Lydia Park.
I would describe it as connected to Lydia Park. I'd describe it as opposite Lydia Park.
Well, I would put to you that it actually physically is connected to Lydia Park by the gate. And you look at it in the context of Lydia Park, the inspector will see it when he goes to the site, is it? You won't be able to see it, sir, on any of the aerials.
So if you turn up my Appeal A proof, page 21, figure 6. Page 21, figure 6.
Are we in the one, my
Appeal
one?
A proof, the one you've got.
Yeah, thank you.
You're very welcome.
You know, I found it really difficult to follow you because I was never given to B because it wasn't my case. So, and you concentrated on B. So
Yeah, sorry.
it was
It's,
causing me lots of problems, which is why I
do
asked you whether
apologise.
the photographs were the same in either.
Yes.
Is the answer yes, they are the same in either?
These ones are.
Yeah.
Well,
no.
these ones are, because these ones, of course, are of Site A.
Don't tell
but,
me more, Mr. Dudley. I'm completely confused anyway, but we've got.
Yeah, I
we've
think
got
I've just lost you even further.
Yeah, I think so.
Right, so are you with us on the Appeal A proof? Okay, so you see figure 6 at the bottom. This was taken within Appeal A site looking south. So you can see in the foreground, there's the surfacing within Appeal A, and then there's the fencing and gates which mark the boundary of Appeal A. Then there's a track, and then beyond that, there's fencing and statics, etc. So that's why I've drawn my view that it's opposite Lydia Park.
Yeah, but there's a gate going completely across it. I mean, I can't produce this in evidence, but I understand. I know I've seen the gate. The inspector will see the gate.
I remember passing through that gate, and I mean,
Okay.
you know, so you can make your decision when you go on the ground and look at it.
Okay.
I'm not disputing there's a gate across the access track,
Right.
but
That gate has been there as long as the site has been there, which I think is over 4 years. I
don't
may
know.
not, maybe under 4 years. I'm not taking that point. So don't get me. But but the appearance is physically as though it's connected to Lydia Park.
as I said, my view is it's opposite Lydia Park for the for the
Okay.
reasons.
But
I've
it's a
given.
matter for the inspector to see and
It is indeed.
make a judgment on. But there is a distinction between how close this site is to Lydia Park and the other pitches that are some way away.
Yes, there is.
Okay, and I'll explore that with Mr. Clark in due course. But thank you for that. It's difficult because I represent 3 clients, but I have a duty to put each site and the differences there. I've already
Of course.
explained that to my clients so that you understand.
Just checking, when you say Mr. Clark, do you mean Mr. Ward?
I do.
Yeah.
Sorry, I'm just misremembering Mr. Ward's name, and I should know by now, but I think everybody universally knows I'm always getting names wrong, and I have done since I was a little boy, so have to forgive me for that. But thank you for pointing it out, because it's I can be offensive to Mr. Ward. Mr. Ward, I apologise. My tailor's called Mr. Clark. Used to be a solicitor, but anyway, nobody wants to know that. Okay, thank you. Do you have any expertise in agricultural or matters of that sort?
In agriculture,
Yeah.
other than university modules, no.
And so you're not an expert in soil damage, are you?
Again, I've undertaken and passed university modules in soil science.
I listen to the Archers, but does that make me an expert?
I think that's a slightly more spurious
Well,
claim.
not really. You
But-
listen to them about the value of soil.
No, but as a qualified forester, and indeed as a landscape architect, I'm aware of the effects of compaction and contamination on soils. In
Where's that
fact-
in your evidence?
Sorry,
Where's that in your evidence?
where's what? That I'm a
References
qualified
to-
forester and landscape
no,
architect, that's in the
Where,
introduction.
where your reference to soil damage on sites being, at sites C and D?
Figure 5 on proof, on the proof for A. Paragraph 3.25, which precedes figure 5 as well, references compaction of soil surrounding trees. And then find it. Reference.
I know it's something that you
And
said in,
para 5.5 as
Okay.
well, discussing damage to underlying.
and what do you
soil.
say?
Sorry? 5.5.
And what do you say, Mr. Dudley?
That the underlying soil has been compacted, contaminated, and probably waterlogged.
Yeah, and where do you say that's irremediable?
Beg pardon?
Where do you say that's irremediable? Which is what you said to my learned friend. Anywhere in your evidence?
I don't know if I use that phrase in
No,
my evidence, but
you don't make the point that damage can't be repaired.
I mean,
clearly-
out with digging out the soil and the subsoil and replacing them with imported media, then, you know, I don't consider that proportional to the scheme before us.
Well, forgive me, it can be repaired, can't it? And you've just explained how.
By some fairly extreme engineering.
Well,
it
not
could.
extreme, farmers do it every day.
Farmers don't remove all the soil from their farm every day.
They do. That's exactly where you're wrong. I mean, according to my long history of the Archers, they give them great examples of needing to do that over time. And sometimes for good husbandry purposes. There is no, that could easily be, if that was a concern, looked at by way of a specific condition and remediated upon, can't it?
In my view, that condition would be excessively onerous to remove topsoil and subsoil from a site.
Well, you see, the
And
problem
then
is
to-
that when you,
And then to create a load-bearing soil from those placed soils that could then support the proposed uses of the site, notwithstanding the fact there's a retained tree within the site as well.
which
the other
site are you
ones-
looking at?
A,
Okay.
there were 2.
Yep. When you're looking at the prospect of your home and you've got disabled people who are living there and you're desperate to keep that, then that's an inconvenience you may very well want to undertake.
That's not a judgment for me to take.
No. But it doesn't mean it's impractical in those conditions, does it?
You're talking about matters of balance there, aren't you?
Yes, sir.
Not for Mr. Dudley.
No, but
In my view,
it's a matter
sir,
for Mr. Dudley to agree it's a matter of balance and planning judgment for you, sir.
in my view,
Because he's
sir,
made the point that he doesn't think it's a condition that's acceptable.
I don't think it's reasonably achievable.
Well, that's different. And again, you don't make that point anywhere in your evidence, do you?
I said it's highly unlikely. to
No,
establish.
you don't make any point about mitigation not being achievable in your evidence, do you?
I say it's highly unlikely.
No,
to
that's what
establish.
you've said to me orally, and that's what you said to Mr. Coughlin orally, but you don't make that point in your evidence. That
Well,
it's either irremediable or that or that a condition could be put on that because it would be unenforceable or unfair. Don't make that point, do you?
What I said, my 5.5, damage to the underlying soil likely to result from the complete surfacing of the site would make future establishment of any planting difficult and is likely causing severe decline of one of the 2 retained trees.
Yeah, so you don't make the point you're making now that difficult doesn't mean impossible, does it? And unachievable by condition. Like, you don't say that, do you?
But the point is that he doesn't say, Alan, you really need to put 3.11 of the rebuttal proof to him. Because that's where he
My
he
learned
says
friend,
it's-
I'm not asking you, I'm asking the witness, I'd like his answer.
Well,
As a final point, you don't make that point, do you? Mr. Dudley? That's a point you've made now, and the inspector can take into account. It's not a point you
Yeah.
made in your, thank you.
Well, what I've said, the inspector has my wording in front of him, so he can determine if there's any difference between the wording in my written evidence and what I've said now.
So those are, I tried not to repeat the things from Mr. Cottle, and I tried to keep within the time, which has been under an hour and a quarter, I think. Thank you.
Thank you, Mr. Masters.
Nice to see you again.
And you, sir. Always a pleasure.
Just a couple of things I think I'd like to check with you,
Yes, sir.
please, Mr. Dudley. First of all, I just want to be understand entirely as a point of reference the extent of two of the areas that we've been talking about, the national landscape and the AGLV. And what I've been using as a quick reference is an appendix that Mr. Ward put in, which is his appendix 13, which says it shows the AGLV and the national landscape, referred to as the A1B there, but I'm not sure if it's quite right. What it shows is that, are you getting it up, Mr. Dudley?
Yes, sorry, sir. Is it appendix CW? Is it one of the CWs?
Yes,
CW 15 is
No, 13.
CW 13.
Yeah.
Okay.
You're being offered one, I think, by Mr. Ward. Did that be quicker?
Oh, sorry. Thank you, Mr. Ward. You're in my blind spot.
Yeah. So
Yes.
what it shows is you can see the boundary along Dunsfold Road to the north of the four
Yes.
appeal sites. And then there's the green diagonal hatching, which shows the AGLV. And then the AONB national landscape as it is now to the north of that. Now, I think that the local plan text about the AGLV indicates that it extends into over the AONB. Or
Yes, I think it does. It says
Or-
that they wash over each other.
that's what I'm not entirely clear about. I do want to be certain. I
not-
don't know if you can assist now, whether you need to go and check that point and come back.
Yeah, I'm not fully conversant with that, sir, I'm afraid.
That perhaps be a policy point, because
Yeah.
I do feel the need to return to
On-
the
on
issue
that
of
point.
policy with Mr. Ward.
Yes. Well, I want to be absolutely clear about this, where the
Mm.
AGLV goes to. And I think what would be helpful, I've got access to the local plan. I wanted to see what the extent overall of the AGLV is, and also the national landscape. The key diagram, which is in the local plan, gives an indication, but it's not really precise enough. I haven't got the policies map. I see Mr. Ward's making a note, and that, I presume that's going to show them.
In some days previously, we used to have a proposals map that showed all the areas of
Yes.
constraint, and it was very easy just to
Very-
look
very
at the table
helpful.
and to see exactly where it is. But
Yeah.
our case is that the AGLV has been serving a role in Waverley, which is treading water, until the boundary review of the national landscape is completed, and then it will be no more.
Well, that's not your case. That's what you've put to nowhere in any of the written documentation.
It's a
That's what you're
policy
just
question.
saying
It's not a
now.
landscape question. It's a policy question for Mr. Ward.
So you can read the documents. I mean, Inspector, I think the only way we can deal with that is to get you the
Policies.
relevant map so you can see exactly what
Yes.
it is.
Yeah.
I mean, we did an appeal at Knoll Lane where we looked at this in some detail, but I can't remember what the answer was just off the top of my head. In Coombe
Right,
as well.
but
we also
I'm
looked
sure
at
the
it.
policies map will give the
But
answers
it does
to
give it,
this.
yeah.
Yeah. So
But
that's
Mr. Dudley probably won't be able to help with that.
right. Anyway, that point's noted. I think the only other thing I wanted to raise at this juncture, Mr. Dudley, and I'm afraid I'm going back to valued landscapes,
Yes, sir.
which you've been asked a lot of questions about, I know. And I think initially, when you were asked about this. I've got a note that you said there were three things that you've taken into account. The fact that it's the AGLV, which you had some lengthy discussion about. The fact that it's the setting, within the setting of the national landscape. And your own analysis
Yes,
contained in your proof.
that's right.
Now, am I right in thinking that your own analysis, in terms of your own analysis, you're looking at the effects of the development rather than anything else?
What I'm referring to in that point, sir, is the extent to which it expresses the local character. So it was an additional point to that. So yeah, it's in the AGLV, it's in the setting of the national landscape, and it's representative of the local character and indeed the national character.
Right. And just in case I've missed it, and I'm still thinking back to box 5.1.
Yes, representativeness is one of the criteria
It is, but
in 5.1 that's being carried through.
do you
to
cover any of the
technical
other
notes.
attributes that are listed in box 5.1?
Yeah, so there's a sort of, but as nature conservation value, essentially, cultural heritage value, cultural associations, landscape condition. So you know the intactness of the landscape.
But those aren't covered, are they?
But no, that's right. Well, I don't undertake the assessment.
No.
To say because it's
So
obvious
the
it's
one that you do
designated, So
you do deal with is the representative point,
yeah, I deal with the representativeness. Yeah,
right? And is that it from?
yeah, that's it. If we're outside of a designation, I'd undertake a technical note test and run through those criteria. But that note is specifically titled "Assessing Landscape Value outside of designations."
Yes. Yeah. Given that document's also been referred to, could you provide a copy of the technical note?
Yes, of course.
Yeah. Yeah. Okay. Thanks, Mr. Dudley. Mr. Lintott, it's time for re-examination.
Thank you. I just have a very few points. The first one, seeing as we started with value landscape, my first question is on that. And could you, Mr. Dudley, just go back to the local plan in 6.6 and page 123, which Mr. Cottle asked you some questions on.
Yeah.
So you were asked questions by both Mr. Cottle and Mr. Masters.
Can I just quickly find it?
Yeah, of course, sorry.
What page are we on?
Page 123 of the plan.
Right.
And it was the question for Mr. Cottle relating to 1335 when you're on that page, Inspector.
Okay, go ahead, Mr. Linton.
Brilliant. So Mr. Cottle put to you 1335 and his stopgap point, and Mr. Masters put to you a line of questions on the NPPF, to which you replied in a manner commensurate with the local plan. Do you remember those lines of questions?
Yes.
So can you have a look, please, at 1337, which appears on the right-hand top corner of page 123, and can you help us with whether that assists you in telling us how the local plan thinks you should deal with this particular designation?
Yes, it does. It says that the planning system should contribute and enhance the natural and local environment by protecting and enhancing valued landscapes. And it says there's strong support for the retention of these local designations among Waverley residents.
And so turn on then to the next page, which is, well, 127. You turn over the page to 127 and look at policy RE3 itself and look at little 2, RE32.
Yeah.
So what does that tell you when you're making a decision in respect of an area of great landscape value you need to do in terms of what the local plan tells you need to do in respect of it?
It says that the same principles for protecting the AONB as was will apply. and that the AGLV will be retained for its own sake as well as the buffer to the national landscape.
And so, can you help the inspector then with how the local plan tells you something is either valued or not valued, and what the effect of that is in MPPF terms, given your answer to Mr. Masters?
Essentially, it suggests that that the valued landscape should be treated in a similar manner. So